Namaskaram, this is CS Rajesh, your log area. Many of you have requested a full-length video on the Indian Contract Act 1872. So I'm back with a video where I'll be providing certain key terms for each and every provisions of the Indian Contract Act 1872, which helps you guys in remembering the provisions as well as to write answers for practical questions in the examinations. If you guys find this video helpful, share it among your friends who are writing examination in the June. So together, let's remove the fear of law and reinstate the love for the law. So let's start with the Indian Contract Act 1872. The Indian Contract Act 1872 is divided into four parts. Part 1, covering section number 1 to 75, provides the general principles of contract. Part 2, covering section number 76 to 123, were providing the provisions with respect to contract of sale of goods. But these section numbers were officially repealed from the Indian Contract Act 1872 in the year 1930, and a separate law was enacted called as the Sale of Goods Act 1930. So, section number 76 to 123 is no more a part of the Indian Contract Act 1872. Then the part 3, covering section number 124 to 238, provides the provisions with respect to special contracts, that is contract of indemnity, contract of guarantee, contract of bailment, contract of pledge and the contract of agency. 5 contracts covered under section number 124 to 238. Then the part 4, covering section number 239 to 266, were providing the provisions with respect to contract of partnership. But these provisions were repealed from the Indian Contract Act in the year 1932, and a separate law was made called as what? The Indian Partnership Act 1932. So, section number 239 to 266 is no more a part of the Indian Contract Act 1872. At present, we have section number 1 to 75, which provides general principles of contract, then 124 to 238, which provides the special contract. So let's start. Section 1 in any act provides 3 provisions: short title, extent, commencement. What is the short title? The Indian Contract Act 1872. Extent, whole of India. Commencement, 1st September 1872. So let's discuss now the formation of contract. How the contracts are formed or how the contract comes into existence. Every contract starts with what? Proposal. Proposal plus acceptance becomes a promise. Promise having consideration becomes an agreement. Agreement which is enforceable by law becomes a contract. I repeat, proposal plus acceptance, promise, promise plus consideration, agreement, agreement plus enforceable by law becomes contract. And there are 4 conditions of enforceability. Section number 10 provides the 4 conditions which are required to be satisfied to be a valid contract. What are they, sir? Fish can laugh at night. That is free consent, competent to contract, lawful object and consideration, which is not expressly declared as void. Sir, how to remember the section numbers of these words are? See, in the equation starts with a proposal, and in the alphabets starts with letter A. And what is the definition section? Section number 2. So 2 subclause A defines the what word? Proposal. Then 2 subclause B defines the what word? Acceptance, the second equation, second step. Promise plus consideration, agreement. So section number 2 subclause C defines the word promiser and promisee. Section number 2 subclause D defines the word consideration. Section number 2 subclause E defines the word agreement, and 2 subclause H defines the word contract. Proposal 2A, acceptance 2B, promiser and promisee 2C, consideration 2D, agreement 2E, and the contract is 2H. This is how the contracts are made in India. Section number 10 provides the essential elements of an valid contract. Section number 10 provides that all agreements are contracts if they are made with a free consent by a person who is competent to contract for a lawful object and consideration, and which is not expressly declared as void. So these are the 4 conditions which are given under section number 10 of the Indian Contract Act 1872. But however, there are 5 more essentials or 5 more conditions which are discovered by the court over a period of time, and these essentials were given to the judgments by the various courts. So even those 5 conditions are required to be satisfied to be a valid contract. So what are these? The first essential, there must be how many parties? two parties, minimum two parties. If they ask question anything with respect to the first essential, you just have to mention that in every contract there must be minimum how many party? Two party, and maximum there is no limit. Remember this keyword, minimum two, maximum no limit, that out of those two parties, one is the offerer, other person is the acceptor. And in case of two parties, the word parties includes whom? Natural person as well as the artificial person. The law requires two parties, but the two parties can be what? Natural person as well as artificial person. For this we have a case study. What is the case name? State of Gujarat versus Ramanlal and Co., in which the court held that in a partnership on dissolution, if a partner takes away the asset, it is not considered as a transfer. Why? Because to be a transfer, there must be how many parties? Two parties, transferor and transferee. But in case of partnership firm, is it any separate legal entity? No, partnership firm is not a separate legal entity. So if the partnership is giving assets to the partner, it means it's just a division of assets of the partnership, because the property of the partnership firm is the joint property of whom? All the partners. So when a partner takes away the asset of the partnership firm, it is considered as what? It is not considered as a transfer, and it is not subjected to tax, because for taxability there must be a transfer. To be a transfer there must be a contract. To be a contract there must be how many parties? Two parties. But in this case the court held that there are no two parties, there are no two parties, there is no transfer, there is no transfer, there is no question of what? Tax. This is what happened in which case law? State of Gujarat versus Ramanlal and Co. But after this case study there are certain amendments brought to the Income Tax Act, where there is a concept called as presumptive transfer. As per that, even in case of transfer of assets, Section 10 provides the essential elements of a valid contract. Section 10 provides that all agreements are contracts if they are made with a free consent by a person who is competent to contract for lawful object and consideration, which is not expressly declared as void. So there are four conditions which are given in the Indian contract under section number 10. Along with that, there are few more conditions which are not given under section number 10. But however, these conditions are discovered by the court over a period of time through its various judgments, and those conditions are also considered as part of the law, and they are required to be satisfied to be a valid contract. So what are these? First one, there must be minimum how many parties? Two parties. So you should write in the examination minimum two parties, maximum no limit. One is the offerer, other person is the acceptor, and this person can be a natural person as well as artificial person. And remember the case study, the case law is State of Gujarat versus Ramanlal and Co. Sir, what happened in this case, sir? I should explain. Section 10 provides the essential elements of a valid contract. Section 10 provides that all agreements are contracts if they are made with a free consent by a person who is competent to contract for lawful object and consideration, which is not expressly declared as void. So there are four conditions under section number 10. But there are few more conditions which are not given under section number 10, but which are based upon the judgment of the court, and even those conditions are required to be satisfied to be a valid contract. What are they, sir? First one, minimum two parties. To be a valid contract, there must be minimum two parties, but there is no limit on the maximum number of persons. Out of those two parties, one shall be the offerer, other person shall be what? Acceptor. One is the offerer, other person is the acceptor. And this person can be what person? A natural person as well as the artificial person. And for this we have a case law called as State of Gujarat versus Ramanlal and Co. So what happened in this case? Ramanlal had a partnership firm called as Ramanlal and Co. along with his wife. Now the question is Ramanlal and Co. and Ramanlal and his wife, are they one and the same or different? The answer is they are one and the same. Why? Because in case of partnership firm, there is no separate legal entity. So when I say partnership firm, it means whom? All the partners. And the property of the partnership firm belongs to whom? All the partners. So after some time, Ramanlal decided to close the business. On dissolution, Ramanlal took away some assets of the partnership firm. At that point of time, the income tax officer demanded the tax from Ramanlal, claiming that It's a transfer of assets from the partnership firm to the Ramallah. The case went to the court and the court held that it is not a transfer. Why? Because to be a transfer, there must be how many parties? Two parties. Here the partnership firm is not a person. We call it as a person. So if it is not a person, there is no transferor. So because there is no transferor, because there is no two parties, there is no contract, no sale, no tax. So this is what happened in which case law? State of Gujarat versus Ramanlal and Co. Where the court held that because there are no two parties, there is no contract, no sale, no tax. State of Gujarat versus Ramanlal and Co. Second one, most important essential element of valid contract based on which they asked questions many times in the previous examinations. There must be intention to create what relationship? A legal relationship. Means क्या होता है सर? The parties must have the intent to create a legal obligation between them. In case of any breach of those legal obligation, they must have the intention to approach the court of law. So while writing the answers for this essential, how you're supposed to start? You should start saying that every agreement should be made with the intention to create a legal relationship. However, in case of social agreement and domestic agreement, the law presumes that there is no intention to create legal relationship. However, this presumption is a what presumption? A rebuttable presumption. Sir, what is rebuttable presumption, sir? There are two types of presumptions in the law. One is rebuttable, other one is irrebuttable. What is rebuttable, sir? The presumptions which can be changed by providing evidence to the court. The court will have a presumption, but that presumption can be changed by providing what? Evidence. Sir, what kind of evidences, sir? In case of intention to create a legal relationship, the court requires the evidence of document to be in written form and it must be registered with a sub-register. So if you have the social agreement or domestic agreement in the written form and if it is registered, is it enforceable by law? Yes, because you have the proof to prove that there is an intention to create a legal relationship. But in general, what is the presumption? In case of social agreement, that is between the friends, domestic agreement between the family members, there is a presumption that there is no intention to create a legal relationship. For this, we have a case study called as Mrs. Balfour versus Mr. Balfour. Who filed a case here? Mrs. Balfour against whom? Mr. Balfour. A wife filed a case against the husband. What happened in this case, sir? Mr. Balfour was a civil engineer in a city called as Ceylon. Happy life with a small family. He got some holidays. So on a vacation, he went to England along with his wife, Mrs. Balfour. In England, Mrs. Balfour got few health issues because of that. In England, Mrs. Balfour got health issues and she got admitted to the hospital and the doctors advised her to stay in the England itself for treatment purpose. While leaving Mrs. Balfour, Mr. Balfour made a promise saying that he promised to pay her £30 every month. So after return to the Ceylon, he heard from few people that Mrs. Balfour is not behaving properly and she is going out secretly with some other person. Because of this reason, Mr. Balfour did not send the money and Mrs. Balfour filed a case against Mr. Balfour. So Mrs. Balfour approached the court and the court held that this agreement is not enforceable by law because it's a domestic agreement. And in case of domestic agreement, there is a presumption that there is no intention to create a legal relationship. And Mrs. Balfour did not have the evidence to prove that she had the intention to create a legal relationship. So who won the case? Mr. Balfour won the case. I repeat, the first essential element is two parties. Second one, intention to create a legal relationship. What is the case name? Mrs. Balfour versus Mr. Balfour. Other formalities to be complied with. If there is a specific law which is governing a certain type of contract, such type of contracts are required to be satisfied with what? The specific law also. The next essential element is the other formalities to be complied with. If there is a contract which is governed by a specific law, that contract must satisfy the conditions which are specified by the specific law. Thus, the statutory requirement like agreement to be in writing, agreement to be signed by witnesses, agreement should be registered, should also be satisfied. to be a valid contract. If these conditions are not satisfied, is the contract valid, sir? No, the contract is not valid, not enforceable by law. The next condition, other formalities to be complied with. A contract must satisfy. The next condition is other formalities to be complied with. If a contract is governed by a specific law, it must satisfy the conditions which are provided by the specific law. For example, if there is a statutory requirement like agreement to be in writing, it should be signed by the witnesses, it has to be registered under the sub-register office, then all those conditions must be satisfied to be a valid contract. If any of those conditions are not satisfied, then the agreement is not enforceable by law. The next condition is certainty of meaning. The meaning of the agreement must be certain. If it is ambiguous, if it is vague, the agreement is not enforceable by law. Next one, possibility of performance. The agreement should be possible to perform. If an agreement is impossible in itself, the agreement is void. For example, promise to discover a treasure by magic and promise to run 10,000 kilometers per minute. Are these things possible? No, because it is not possible to perform, not enforceable by law. So these are the 5 essentials which are based upon what? Based on interpretations. Along with that, there are 4 more conditions as per section number what? 10. That is pre-consent, competent to contract, lawful object and consideration, which is not expressly declared as void. We will discuss those topics later under the concept called as other essential elements of a valid contract. Next one, types of contract. Types of contract. The contracts can be classified into 3 categories. How many categories? 3 categories. One, on the basis of validity. Second one, on the basis of creation, and the third one on the basis of execution. On the basis of validity, first one, what is the first contract? A valid contract. So what is valid contract, sir? A contract which is enforceable by law. It is called as what contract? A valid contract. Section number 2H. I repeat, an agreement which is enforceable by law is called as what contract? A valid contract. Next one, void agreement. So what is void agreement, sir? An agreement which is not enforceable by law is called as what? Void agreement. Section number 2, clause G, 2G scam, 2G. And these agreements are what? Void ab initio. What is void ab initio, sir? Void from the beginning itself. And keep this in mind, in case of void agreements, the collateral agreements are valid. What is collateral agreements, sir? Supportive agreements are valid. Next one, void contract. What is void contract, sir? You must write this keyword called as ceases to be enforceable by law. Void contract is a contract which ceases to be enforceable by law. That is called as what? Void contract. Unlike void agreements, void contracts are absolutely valid and enforceable at the time of contract was made. But later, due to some unforeseen event or supervening impossibility, the agreement ceases to be enforceable by law. That is called as what contract? A void contract. Next one, voidable contract. The contract is voidable when it is enforceable at the option of one or the more, but not at the option of other or others. It is called as what contract? A voidable contract. I repeat, if a contract is enforceable at the option of one party, if there are more than one party, one or more, but not at the option of whom? Other or others, it is called as what contract? A voidable contract. There are 3 scenarios in which a contract becomes voidable. First one, when the consent is not free, the person whose consent is not free will have an option to cancel or to make it valid. So only at the option of the person whose consent is not free. Next one, section number 53. If one person prevents the other person from performing the promise. For example, A prevents B from performing his promise. Now, this contract is voidable at the option of whom? The person so prevented. Who is prevented here? Mr. B. Now, Mr. B has the option to cancel it. Section number 53. Section number 55, where in a reciprocal promise, time is the essence. And if one party fails to perform the contract upon the agreed, the other party has the option to cancel it. So these are the 3 scenarios in which a contract becomes voidable. Last one, illegal agreement. So what is illegal agreement, sir? The agreements which are forbidden by law, are punishable by law, are called as which agreement? Illegal agreements. And in case of illegal agreements, the collateral agreements are also what? Tainted. Remember this word, tainted. It is also tainted with what? Tainted with illegality. And are they valid or void? Void, not enforceable by law. I repeat, in case of illegal agreements, even the collateral agreements are also tainted with illegality and hence they are void. But in case of void agreements, the collateral agreements are valid. So these are the types of contract based on what? Validity. What is the first one? Valid, enforceable by law. Void agreement, not enforceable by law, and they are void ab initio. Void contract ceases to be enforceable by law. Voidable contract enforceable at the option of one or more, but not at the option of other. And what is the section number? 19, 53, 55. Next one, illegal agreements which are forbidden by law or punishable by law, called as illegal agreement. In case of illegal agreements, even the collateral agreements are also tainted with illegality and hence they are void, not enforceable by law. Next one, on the basis of creation, means how the contracts are made. It can be classified into how many types? The following types. What is the first one? Expressed contract. What contract? Expressed contract. Section number 9 provides that when the proposal or acceptance is expressed by words, it is called as expressed contract. Implied contract, where the contract is made by implication. Again, section number 9. Where the contracts are made by implication of the law or by the action, it is called as what contract? Implied contract. If proposal or acceptance is made by words, express contract. Other than words, implied contract. So, is there implication of the law or an action? That is implied contract. Tacit contract, which are inferred through the conduct. Remember the word inferred through the conduct. It is called as what contract? A tacit contract. And tacit contracts are contracts where the acceptance is conveyed silently. Best example for tacit contract is ATM or auction sale. Tacit contracts are also part of which contract? Implied contract. Next one is quasi-contract. What are quasi-contracts? Quasi-contracts are not the actual contracts, not made by the parties, but these are created by the law or imposed by the law to provide the justice. So these are the 4 types of contract based on what? Creation. What is the first one? Express contract, implied contract, tacit contract, quasi-contract. Proposal or acceptance by what? Express contract. Other than words, implied contract. Conduct, tacit contract. Imposed by the law, quasi-contract. Next one, execution. On the basis of execution, that is the performance, the contract can be classified into what? Following types. What is the first one? Executed contract. What contract? Executed contract. So now what is executed contract, sir? Executed contract is a contract where the act is done or a forbearance is brought on record at the time of entering into a contract itself, because we know that consideration can be what? It can be an act or it can be a forbearance. Correct, right? So when the consideration is brought into record at the time of entering into a contract itself by both the parties, it is called as what contract? Executed contract. The act is done or forbearance is brought on record, it is called as what contract? Executed contract. Next one, executory consent contract, where the consideration to be given on a future date, that is after the contract is made, it is called as what contract? Executory contract. And this executory contract can be what? Unilateral as well as bilateral. What is unilateral? If only one party obligation is pending on a future date, it is called as what? Unilateral contract. If both the parties obligation is pending, bilateral contract. So these are the various types of contract on the basis of what? On the basis of execution. Okay, first one on the basis of validity, second one on the basis of creation, and the third one is on the basis of what? Execution. On the basis of validity, valid 2H, void agreement 2G, void contract 2J, and voidable contract 2I. Illegal agreements which are punishable by law. Creation, expressed, implied, tacit, quasi. Execution, executed, executory. Executory how many types? Unilateral and bilateral. So these are the types of contracts. Next topic, offer. Section 2A defines the word what? Offer. So what is offer, sir? When one person signifies his willingness to do or abstain from doing something with the intent to obtain the assent of that other person to such an act or an abstinence is said to make what? Offer or a proposal. So in an offer there should be minimum how many parties? 2 parties, offerer and offeree. So what offerer does? He expresses his willingness to do or abstain from doing something with the intent to obtain the assent of that other person to such an act, positive or an abstinence, when he said to make what? Offer. Types of offer. Offer can be what? Expressed. When the offer is made by using the words, it is called as what? Expressed offer. Other than words, implied offer. Then the next one is specific offer. What is specific offer, sir? Keywords are offer made to an ascertained or a specified person. Remember this. Offer made to an ascertained or a specified person. It is called as what offer? A specific offer. Then what is general offer, sir? If an offer is made to a public at large and which anyone can accept, it is called as what? A general offer. Keep this in mind. A general offer can be accepted by performing the conditions of the offer, which is called as implied acceptance. Section number what? Section number 8. 8, accept it by performing it. So a general offer can be accepted by performing the conditions of the offer or by receiving the consideration offered in the reciprocal promises. So first one, expressed offer by words. Second one, implied offer other than words. Third one, specific offer made to an ascertained person or a specified person and which can be accepted only with that particular person to whom the offer is made. Private placement of securities is a specific offer. Only the person to whom the offer is made can accept it. General offer made to public at large and anyone can accept it by performing the conditions of the offer. For this we have a case study called as what? Carlyle versus Carbolic Smoke Ball Company Limited. What happened in this case, sir? The Carbolic Smoke Ball Company Limited invented a medicine called as smoke ball. Because they were confident about this medicine, they made an advertisement stating that if anyone consume their medicine called as smoke ball as per the prescribed direction and get affected with influenza, they will pay some reward. Miss Carlyle, she read those advertisement and she has consumed the smoke ball as per the prescribed direction, but still she got affected with the influenza. She filed a case against the company, but company refused to pay the compensation, saying that there was no acceptance, express acceptance. But the court held that in case of general offer, the offer can be accepted by performing the conditions of the offer. In this case, Carlyle has accepted the offer by consuming the medicine. That is what called as performing the conditions of the offer. So there was an acceptance, hence the Carlyle won the case. Clear? Expressed offer, implied offer, specific offer, general offer. Next one, cross offer. When I say cross offer, remember this word, similar offers by each party. When the parties exchange a similar offer to each other without knowing the offer of other person and where the terms and conditions are identical, it is called as what offer? A cross offer. Cross offer takes place where there is a delay in communication, especially in case of offer by letters. What are the keywords? Similar offer to each other without knowing the offer made by the other party and the terms and conditions are identical. Next one, counter offer, important hai. What is counter offer, sir? When the offeree offers to accept the offer of the offerer, subject to some modifications or condition of the original offer. Such offer of the offer is called as what? Counter offer. There are two parties, right? Offerer, offeree. When the offeree offers to accept the offer of the offerer, subject to some conditions or modifications, means offeree is putting some conditions or modification to accept the offer. So when she accepts or when he accepts the offer subject to some conditions or modifications, such an offer of the offer is called as what offer? Counter offer. In case of counter offer, which offer will lapse? The original offer will lapse. It results into lapse of which offer? Original offer. Counter offer. Next one, standing, continuous or open offer. What is the keyword, sir? If the offer intended to remain open for a specific period or a specified period during which it can be accepted anytime, it is called as what offer? Standing, continuous or open offer. Repeat. Intended to remain open for a specific period, can be accepted anytime during that period, and this offer is called as what offer? Standing offer or a continuous offer or open offer. The organizations, when they need the goods from time to time, remember this word, time to time. Whenever the word time to time is used, it means what offer? Standing, continuous or open offer. So if an organization needs the goods from time to time, they invite a tender from the public. The person who submit the tender, that submission of the tender is called as what? Called as the standing offer or open offer. Organizations invite the tender. That is called as invitation to offer. So based on that, when the other persons make an offer to supply the goods from time to time, such tender is called as what? Offer. Which offer? Standing offer, continuous offer, or open offer. I repeat, there are 7 types of offer. What is the first one? Expressed by words, implied other than words. Third one, specific offer, specified person, only he can accept it. General offer, made to public at large, anyone can accept it by performing the conditions of the offer. Next one, cross offer, that is where the terms and conditions are identical, similar offers are exchanged between the parties. Next one, counter offer, when the offeree agrees to accept the offer of the offerer subject to conditions or modifications. That is called as what offer? Counter offer. Standing offer, which is intended to remain open for a specified period and which can be accepted at any time during that particular period, is called as what offer? Standing, continuous, or open offer. So these are the 7 types of offers. Next one, important point, the essential elements of a valid offer. So to be a valid offer, the first one, offer should be capable of creating what relationship? Legal relationship. Important condition, because based on this they ask questions in the previous examination. They'll ask practical question. So to be a valid offer, the offer must be capable of being accepted and giving rise to what relationship? A legal relationship. If an offer is not intended to give a rise to legal relationship, then it is not valid. Keep this in mind. Offer should be capable of being accepted and giving rise to legal relationship. If the offer is not intended to give a rise to legal relationship, is that offer valid? No, offer is not valid. So in case of social invitation, there cannot be a legal relationship. Why? Because social invitation is not capable of creating what relationship? A legal relationship. So social invitation, even if it is accepted, does not create a legal relationship. So these are the key words to be remembered to write answers for intention to create a legal relationship in case of offer. What is that? Offer should be capable of being accepted and giving rise to legal relationship. Offer should not be, if offer is not intended to give a rise to the legal relationship, then it is not valid. And social invitation, even if it is accepted, it does not create any legal relationship. Next one, offer must be certain, definite, and not vague. That oil example, fruits example. Next one, it must be communicated to the offeree. One more essential of valid offer, based on which they can ask questions in the examination. To be a valid offer, offer must be communicated from offerer to the offeree. If offer is not communicated, can there be an acceptance? No, it should write, unless offer is communicated, there can be no acceptance. And an acceptance of an offer in ignorance of the offer is not an acceptance. It is always like communication of offer you get to know about it, then you can give an acceptance. If he give an acceptance without being aware about the offer, is it a valid acceptance? No. For this, we have a case study called as Lalman Shukla versus Gauri Dutt. What happened in this case study, sir? Gauri Dutt's nephew was missing. He sent his servant Lalman Shukla to trace his nephew. After Lalman Shukla left, he made an offer to give a reward, which Lalman was not aware of. Without being aware about the offer made by Gauri Dutt, he found the nephew of Gauri Dutt. Later, he claimed the reward amount, but court held that Lalman Shukla is not entitled to the reward. Why? Because when he performed the conditions of the offer, that is, when he gave an acceptance, he was not aware about the offer. And we just now discussed acceptance of an offer in ignorance of the offer. Is it a valid acceptance? No, not a valid acceptance. Next one, offer should be made with the intent to obtain the assent of the other party. Obviously, definition itself says, right? Offer means what? When one person signifies his willingness to do or abstain from doing anything with the intent to obtain the assent of the other party. So obviously, the one of the essential element is the offer must be made with the intent to obtain the assent of other party. Next one, offer may be conditional. For example, RTGS and payment conditions. So offer may be conditional, but not the acceptance. Next one, offer should not contain a term the non-compliance of which would amount to acceptance. Important. See, offer can be conditional, but you cannot put a condition in the offer in such a way that if the other person does not respond to your offer, it becomes an acceptance. Is that such kind of offers are valid? No. You cannot impose a burden upon the offeree to respond. You can presume the rejection by silence, but not the acceptance by silence. If you put a condition in an offer in such a way that the Non-response from the promisee or offeree would amount to acceptance. Such kind of offers are not valid. Out of all these, the most important essential of valid offer is different from invitation to offer. If they ask question in the examination about invitation to offer, you should always start with your word answers with a definition of offer. First write what is offer, then write invitation to offer. If possible, write few differences. Then you can compare the facts given in the question to the provisions and write the answer. So what is offer? Offer is the final expression of willingness. Keep this in mind. Offer is the final expression of willingness by offerer to be bound by the offer if the other party chooses to accept it. It's a final expression of willingness by the offerer. And if the offeree chooses to accept it, who is have the intention to be bound by it? Offerer. But in case of invitation to offer, it is not a final expression of willingness. Here the person is just proposing the terms on which he is willing to negotiate. You should keep this in mind. Not a final expression of willingness, and he proposes the terms on which he is willing to negotiate. That is called as invitation to offer. In case of offer, the person has the intention to be bound by it if the other person accepts it. But in case of invitation to offer, the person has the intention of negotiating on the terms. It's just a negotiation. Next one, offer is always subsequent to invitation to offer. It cannot precede the invitation to offer. But invitation to offer is always what? Precedent to the offer. So offer plus an acceptance becomes what? Promise. Whereas invitation to offer plus acceptance becomes what? Offer. These are the difference between offer and invitation to offer. Keep this in mind. Invitation to offer, not a final expression of willingness, and he has the intention of negotiation. Whereas offer is the final expression of willingness where the party has the intention to be bound by it if the other person accepts it. Examples for invitation to offer: statement of intention or announcement. A father has made an announcement saying that he's gonna will all his property to his son. Is it an offer? No. Statement of intention or announcement is not an offer. It is a what? Invitation to offer. Offer should be distinguished from what? Answer to a question. If there is just an answer to a question, is it called as an offer? No. It is called as what? Invitation to offer. For this, we have a case study called as what? Harvey versus Facey. Where what happened? A person sent a telegram stating that if you do not respond, what is the lowest price? Please state the what is the lowest price of the bumper hull pen. Telegraph the bumper hull pen. So they have sent a telegram stating that will you sell your bumper hull pen? Telegraph the lowest price. Then the Facey replied stating that the lowest price is some amount. For this, RV replied saying that we shall accept to purchase the bumper head at that particular stated price. But Facey refused. For this, Harvey filed a case. Will he succeed? No, because the answer of the Facey stating the price is just an invitation to offer. It's just providing the information. So answer to a question is not an offer. It is just an invitation to offer. Statement of price is not an offer. Invitation to make an offer or to do business is also not an offer. It is what? Invitation to offer. Goods sold through auction. Based on this point, they ask questions many times in the examinations. If the goods are sold at auction by issuing a invitation, is that auction notice is considered as an offer or invitation to offer? Invitation to offer. For example, if a company gives an auction notice saying that they're going to auction something, and if people travel from different places and gather at the particular place, if the auction is cancelled later, can they file a case against the auctioneer? The answer is no, because that notice given is only what? Invitation to offer. So the auction notice is sent first, then they will gather. By bidding, they will make an offer that can be accepted or rejected by the auctioneer. So auction notice is what? Invitation to offer. We also have few more examples: catalogs, price list, quotations, circulars, inviting tenders, display of goods in the shopping complex with a price tag, railway timetable, prospectus, newspaper advertisement other than for reward. All these are considered as what? Invitation to offer. An acceptance of invitation to offer results into what? Offer, but not a contract. Clear? Section number 2A. Definition of offer is important. Types of offer, essentials of a valid offer, in that intention to create legal relationship, communication of offer, and difference between offer and invitation to offer. Section number 2, subclause A. Section number 2, subclause B defines the word what? Acceptance. What is acceptance, sir? Simple definition: when the person to whom the offer is made signifies his assent thereto, means to the offer, it is called as what? Acceptance. And an accepted offer becomes what? Promise. Remember the equation: offer plus acceptance, promise, promise plus consideration, agreement, agreement plus enforceable by law, contract. Offer, when it is accepted, becomes what? Becomes a promise. And what is acceptance? Remember the keyword: when the person to whom the proposal is made signifies his assent to the offer, it is called as acceptance. Legal rules of acceptance, important one. First one: acceptance must be given only by the person to whom the offer is made. If the offer is made to CSR, who should give acceptance? CSR should give acceptance. If the offer is made to Harishchandra, who should give acceptance? Harishchandra should give the acceptance. And for this we have a case law. What is the case name? Bolton versus Jones case law. What is the case name? Bolton versus Jones, where Jones made an offer to Brocklehurst, but instead of Brocklehurst, who gave acceptance? Bolton gave acceptance. Is the acceptance valid? No. If acceptance is invalid, how can Bolton file a case against Jones? He filed a case. Will he succeed? The answer is no, because Bolton, the offer was made to whom? Brocklehurst. Who should give acceptance? Brocklehurst, not the Bolton. So to be a valid acceptance, acceptance must be given only by the person to whom the offer is made. Second one, the acceptance must be absolute and unqualified. If the acceptance is subject to conditions or modifications, it is considered as what offer? Counter offer. So how to write the answers for this? You should write sitting that acceptance must be absolute and unqualified, and it must be expressed in the usual or reasonable manner. What is usual manner, sir? Hague Martibrew in the previous transaction, in that manner. Usual or reasonable manner. Unless the proposal prescribes the what? Manner of acceptance. I repeat, the acceptance must be absolute and unqualified and should be expressed in the usual and reasonable manner, unless the proposal prescribes the manner of acceptance. But however, if an offeree gives the acceptance subject to compliance of the conditions of the law, is it considered as an qualified acceptance? No, because the law conditions are to be satisfied by each and every person. And for this there is an example. Remember, a person says, I will purchase the car subject to you having the valid RC book. Is it a counter offer? No, it's a valid acceptance, because he's not putting any extra conditions over there. So if they ask that kind of examples questions, what he will write? Acceptance to be valid must be absolute and unqualified, must be expressed in the usual and reasonable manner, unless the proposal prescribes the manner of acceptance. Next one, like offer, even the acceptance must be communicated. It has to be communicated in what manner? Reasonable manner, or in the usual form, unless the offerer has prescribed the specific mode of acceptance. If it is not communicated, or if it is a conditional one, is the acceptance valid? No, because without the communication, acceptance is not valid. And before a person gives the acceptance, is he required to be aware about the offer? Obviously yes, there must be communication of offer first, then the communication of acceptance. There are few case laws for this. Remember, first one, Brogdon versus Metropolitan Railway Company, where he signed the acceptance, kept in the drawer. Is it a valid acceptance? No. Central Bank versus Venkatesh, just passing of resolution in the meeting, is it called as acceptance? No, it has to be what? Communicated by the offeree or by his authorized agent. Next one, important one, the acceptance must be in the prescribed mode. Remember section number 17, section number 7, acceptance must be absolute and unqualified and should be expressed in the usual or reasonable manner, unless the offer prescribes the specific method of acceptance. Sir, what happens if the promisee accepts the promise other than the method in which it is specified? What happens in that scenario, sir? In that scenario, the promisee should protest it. The promisee should reject the acceptance. But if he remains silent, then the acceptance presumed to be valid. I repeat, if the promiser does not insist on the proposal being accepted in the manner prescribed after it has been accepted otherwise, then the proposer presumed to have consented to that acceptance. Proposer has put a condition saying that proposee should accept the offer in telephone, but proposee gave acceptance by letter. Now the validity of the acceptance depends upon the proposer. if the proposer does not insist on the proposal being accepted in the manner prescribed after it has been accepted otherwise, then the proposer presumed to have consented to that acceptance and the acceptance is valid. Time, the offer should be accepted if it is specified within the specified time, if it is not specified within the reasonable time. Mere silence, maunam sammati lakshanam, is it an acceptance? No, mere silence is not an acceptance. You can presume the rejection by silence but not the acceptance by silence, but there is one exception. I repeat, yes, acceptance cannot be implied from silence or failure to answer to your question. But there is an exception. What is the exception? Where the offeree has in his previous conduct indicated that silence itself is the evidence of acceptance. Means where it was agreed in the previous conduct that silence of the offeree itself is an acceptance. Then silence can be considered as what? Acceptance. Other than that exceptional cases, an acceptance cannot be implied from silence or failure to answer to a question. Seventh one, acceptance by conduct or implied acceptance, section number 8. 8, accept it by performing it. Correct, right? So acceptance can be either expressed one by words or by implied one. What is implied one, sir? The promisee can accept the promise. Offeree can accept the offer of the offerer by performing the conditions of the offer or by acceptance of consideration for the reciprocal promises. So these are the 7 rules of what? Acceptance. Next one, section number 3, communication of offer and acceptance. Sir, how the offer can be communicated, sir? The offer can be communicated either by words or by conduct, oral words or written words, or by actions. Acceptance, the acceptance can be communicated by the offeree to the offerer by what? Act, that is words, expressed or implied. Second one, communication by omission. Remember, there is an example, not to arrive to the court. So a person made a promise to pay 1 lakh rupees if he does not come to the court. If a person does not come to the court, it means what? He has given the acceptance by omission of doing something. Next one, or by conduct, where a person gives an acceptance by certain signs or pictures or by actions. So the communication of acceptance can be either by words or by omission or by conduct. Section number 3. Section number what? 3. Section number 4. Section number 4 provides the provision with respect to what? Communication when complete. So when the communication is complete, in case of offer, when the communication of offer is complete, and in case of acceptance, when the communication of acceptance is complete. Proposal, in case of proposal, the communication is complete when it comes to whose knowledge? Offeree's knowledge. Means offeree should read the letter of the offer and it should be aware about it. And only what is complete? Offer is complete. But for acceptance, we have a different rule. Against the proposer. Who is proposer? The one who makes the proposal. Against the proposal, it is complete when it put into what? Course of transmission, out of whose control? Acceptor control. Once the acceptor put the letter into course of transmission, out of his control, what is complete? Acceptance is complete against the proposer. Means he cannot change his offer. Against the proposee, when it is complete, when it comes to whose knowledge? Offerer's knowledge. Only when the letter of acceptance reaches to the offerer, who is bound by it? Offer is bound by it. Communication of special condition, important. What are special conditions, sir? The conditions which are conveyed tacitly are called as what conditions? Special conditions. For example, this railway ticket or air ticket, in that there is a conditions which are mentioned at the backside and which are conveyed to the other person silently. And even if he is not aware about it, is he bound by it, sir? Yes, he is bound by it. So special conditions are the conditions which are conveyed tacitly, and even the acceptance is also conveyed tacitly. And these conditions must be what? Reasonable. If they are unreasonable, it is not valid. And for that, we have a case law called as Lily White versus Manuswamy, where the laundry person has promised to pay only 20% of the value of the cloth if it is lost. Is it valid? No, because it is unreasonable. Next one, standard forms of contract. See, standard forms of the contracts are the contract where the terms and conditions remain the same. And the standard forms of contract will contain what? Special condition. So the special condition may be enforced on the other party who is subjectively unaware about the contents of the document, provided the party wanting to enforce the contract has given what notice? A reasonable notice. Important in a standard forms of contract. The special conditions may be enforced on the other person who is not aware about the contents of the document, provided that the party wanting to enforce has given what notice? A reasonable notice. But that reasonable notice must be given when the contract was made, not after the contract was made. For that, we have a case law called as Raipur Transport Company versus Gansham, where the conditions were communicated after the contract was made. Is it valid or invalid? Invalid. Can it be enforced? Cannot be enforced. Cannot be enforced. Next one, we have the revocation. We have what? A revocation. Revocation means what? Cancellation. Revocation means the cancellation. Correct, right? Cancellation of offer and acceptance. Section number क्या है? Section number 5. As we know, offer can be revoked before it is complete against whom? Against the proposer. Who is proposer? Offerer. Before the acceptance is complete against the proposer, what can be revoked? Proposal can be revoked. And when acceptance can be revoked? Acceptance can be revoked at any time before the communication of acceptance is complete against whom? Against the acceptor. That is, offerer can revoke his offer before offeree put letter of acceptance into course of transmission. Acceptor can revoke his acceptance before letter of acceptance reaches to the offerer. Clear with this? So revocation of acceptance is possible only when the acceptance is given by what? Given by post. What if letter of acceptance and withdrawal of acceptance reaches at the same time? Then it depends upon what is read first. If acceptance is read first, there is a valid contract. If revocation is read first, then the contract is revoked. Section number 6 provides the modes of revocations. There are various modes or various situations in which the offer comes to an end. What is the first one? By notice of revocation, offerer gives a notice of revocation before the offer acceptance is complete against him. Offer comes to an end. Second one, lapse of time. If the offeree fails to accept the offer within the specified time, if not specified within a reasonable time, for example, banana, it can be 3 days, and for some other goods, it can be 3 months. So what is reasonable time is a question of fact. If the offer is not accepted within a reasonable time, the offer will lapse. Next one, by non-fulfillment of condition precedent. If the offerer has prescribed a specific condition to be fulfilled before the offeree accepts the offer, and if the offeree fails to fulfill those conditions, offer will lapse. For example, depositing earnest money, executing certain document, or obtaining a degree. These are the preconditions to be satisfied. Next one, by death or insanity, if the offerer dies, and if it involves a personal gain, offer is invalid. Offer is automatically revoked. However, if the offer involves the goods and if the offeree accepts the offer without being aware about the offer, the acceptance is valid and it can be enforced against whom? Against the legal representative of the offer. Counter offer, we know what is counter offer. When the offeree offers to accept the offer of the offerer subject to conditions and modification, such an offer of the offer is called as what offer? Counter offer. In case of counter offer, which offer will lapse? Original offer will lapse. Next one, by non-acceptance of the offer in the prescribed mode. If the offeree gives the acceptance other than the mode prescribed, then the offerer has the right to contest it, right to reject it. But if he does not contest it, then the law presumes that he has consented for such acceptance and acceptance is valid. But if he rejects it, the offer will come to an end. Next one, by subsequent illegality. If the law declares an offer as invalid, then the offer comes to an end. So these are the cases. Section number 6 provides the cases in which what comes to an end? Contract comes to an end. So let's recall the section number. Section number 1 is what? Short title, extent, commencement. Section number 2 is what? Definition. 3, communication of offer and acceptance. 4, when the communication of offer and acceptance is complete. 5, revocation. 6, modes of revocation. 7 is an absolute. Acceptance must be absolute and unqualified. 8, accept it by performing it. Accept the offer by performing the conditions of the offer. 9, offer can be expressed as promise can be expressed as well as implied. 10, essential elements of what contract? A valid contract. 4 plus 5. Here, let's go to the next one. Next one. Consideration. Section number 2, subclause D defines the word what? Consideration. Definition is important. What is consideration? When at the desire of promisor. Keep this in mind. Desire of the promisor. This is the fundamental rule of consideration. What is the fundamental rule of consideration? The consideration must always happen at the desire of the promisor. Desire of the promisor. Desire of the promisor. When at the desire of the promisor, promisee or any other person, either promisee can do or any other person can do on behalf of the promisor. Promisee or any other person has done something or abstain from doing something or promises to do something, done, past, abstain from doing, negative, or promises to do something, future. So consideration can be a positive as well as negative. Such an act, abstinence, or a promise is called as consideration for the promiser. See, every promise must have consideration. Without consideration, promise is invalid. So when at the desire of the promiser, promisee, or any other person, we don't care who is doing it, but he should do at whose desire? Promiser desire. When at the desire of the promiser, promisee, or any other person has done, past, or abstain from doing, negative, or promises to do something, such an act, abstinence, or a promise is called as consideration. In the Misa versus Curie case law, it was held that consideration can be positive, negative, act, suffering of one person, disadvantage caused to the one person can be consideration to the other person. So based on definition itself, we have legal rules of consideration. First one, consideration must move at the desire of the promiser. Remember this keyword. Consideration should be at the desire of whom? Promiser. If it is not done at the desire of promiser, or if it is done at the desire of a third party, not a valid consideration. And acts done voluntarily or services without any request cannot be considered as a valid consideration. Both the points should be there in your answer. Consideration should move at the desire of the promiser. If it is not done at the desire of promiser, or if it is done at the desire of a third party, not a valid consideration, and acts done voluntarily or services without any request cannot be considered as a valid consideration. For this, we have a case study, Durga Prasad versus Baldio, where the construction of complex happened at the desire of a collector. However, the shop owner has made a promise to the builder stating that he's going to pay the commission on the goods he sells. Because the shop owner has not received the consideration from the builder, because the construction happened at the desire of whom? Collector. There was no consideration, no contract. Next one, consideration may move from promisee or any other person. Law requires that consideration must be at the desire of promiser. But who can provide the consideration? Anybody can provide consideration, promisee or any other person. It is immaterial who furnishes the consideration. It can be done by the promisee or any other person. We don't care. For this, we have a Chinnaya versus Ramaya case law, where on behalf of Chinnaya, who gave consideration? A old lady gave a consideration to Ramaya. So the court held that contract between Chinnaya and Ramaya is valid. Next one, consideration can be past, present, future, before the date of promise, past, simultaneously with the promise, present, after the formation of contract, future. Keep this in mind. Consideration at the desire of the promiser, from promisee or any other person, it can be past, before the date of promise, simultaneously, present, after the formation, future. Next one, consideration need not be adequate. Important one here. Consideration need not be of particular value or approximately equal value for which it is exchanged, but must be of something law would regard as what? Having value. So interesting framing of words. It need not be of particular value, need not be of approximately equal value for which it is exchanged, must be of something law which would regard having what? Value. If it is shockingly less, if the consideration is shockingly less, then if one person if he alleges that his consent was not free, such fact that the consideration is shockingly less can be taken into consideration as an evidence, and it can be considered as the consent was not free. Here, section number 2, clause D, subclause D is consideration. Consideration need not be adequate. It has to be some value in the law, but it need not be adequate. It can be 1 rupee, 2 rupees, 5 rupees, 10 rupees, etc. Performance of what one legally bound to perform. Is it a valid consideration? No, because you are not doing anything in the new promise, right? If you make a promise to perform which you are already bound to perform, or which is already your existing obligation, either as per the general law or as per the existing contract. Is it a good consideration? Not a good consideration. A promise to do one is already bound to do either by the general law or existing contract, not a good consideration because it add nothing to the pre-existing contracts. A promise to perform the public duty, is it a valid consideration? No, because the public officers already have a public duty. They have a duty as per the law to provide that service at free of cost. If they charge consideration for such promises, is it valid or not valid? Not valid. For example, the most classic example is promise to pay money to the witness. Can a witness take a money for giving a witness? No, it's his obligation. And if he entered into a contract to receive the money for giving a witness, is it valid? Not valid, not enforceable by law. Next one, consideration must be real and not illusory. If it is illusory, is it valid? No, it should not be illusory. If it is illusory, is it valid? No. For example, promise to bring a Taj Mahal, promise to build a Taj Mahal. Is it possible? No. Physically impossible. Bringing a moon from the sky, not valid. Consideration must not be unlawful, immoral, or opposed to public policy. We will discuss this in detail under section number 23 of the Indian Contracts. But keep this in mind. There are 7 essentials of valid consideration. What are they? At the desire of the promiser, promisor or any other person can provide consideration. It can be past, present, or future. Need not be adequate. Must be real and not illusory. And must be not be unlawful, immoral, or opposed to public policy. Then we have the 2 important rules, section number 25 and the privity of contract. Section number 25 provides an important one based on which they can ask questions in the examination. Section 25 clearly provides that section number 25 clearly provides that any agreement, any agreement without consideration, any agreement without consideration, valid or void? Void. Keep this in mind. Any agreement without consideration, void. But are there any exception to this rule? Yes, there is an exception to this rule. In the following class cases or following agreements, even if there is no consideration for both the parties, is the agreement valid? Yes, it is valid. What is the first one? Agreement made out of natural love and affection, subject to how many conditions? 4 conditions. What are they? Natural love and affection, near relationship, writing, and must be registered. If these 4 conditions are satisfied, even if there is no consideration for both the parties, is the agreement valid? Yes. Agreement made out of natural love and affection, subject to how many conditions? 4 conditions. Natural love and affection, near relationship, writing, register. Next one, compensation for past voluntary services. Are voluntary services or valid considerations? Sir, no sir, it is not a valid consideration. But however, if there is a promise to compensate for past voluntary services, subject to how many conditions? 4 conditions. Is it valid? Yes, valid. What is the first condition? Service rendered must be voluntarily. Services are rendered by whom? By the promiser. Promiser must be in existence at the time when the service was rendered. And the promiser must have the intention to compensate. Must. It means it should be in writing. First, what is the first condition? Services are rendered voluntarily. Services are rendered for the promiser. Promiser must be in existence at the time when the service was rendered, and the promiser should be intended to compensate whom? Compensate the promisee. Next one, third one, important, promise to pay time bar debt. What is time bar debt, sir? When a person has a right to file a suit to recover a debt, he must file a case within how many years? 3 years. As per which act? Limitation Act. If the case is not filed within 3 years, it becomes what debt? Time bar debt. Is it recoverable now? No. In the court of law, it is not recoverable. But however, if the person who is liable to pay the debt, that is the time bar debt, if he makes a new contract and he promises to pay the time bar debt, is it valid? Yes, it is valid if it is in what? If it is in written form. A promise in writing signed by the person making it or by duly authorized agent, valid or not valid? Valid even if there is no consideration. Next one, agency contract, section number 182. 182 agent to 183 agent to 185 provides that agency can be with consideration or without consideration. Gratuitous as well as non-gratuitous, both are valid. So one of the exception is agency, where even without consideration enforceable by law. Next one, completed gift. What is completed gift? Where the possession of the gift is transferred from the donor to the donee. It is called as what? Completed gift. In case of completed gift, what is not required? Consideration is not required. Bailment What is bailment, sir? Delivery of goods by one person to another person upon a condition the goods shall be returned or disposed upon the completion of the purpose for which the goods are delivered. So that is called as bailment. Bailment can be with consideration or without consideration. Gratuitous, without consideration. Non-gratuitous, with consideration. Charity, generally charity agreements are not enforceable by law because there is no consideration for both the parties. But if the promisee has undertaken some liability or if he has done something based upon the promise of the promiser, then to the extent of work done, is it valid? Yes, it is valid and it is enforceable by. So next we have an important rule, sued by third party. Can a third party interfere between the parties to a contract? The answer is no, because contract is a private arrangement between the parties and it creates only a relationship between the parties and it creates rights and duties or rights and liabilities only between the parties to a contract. It means a stranger or a third party cannot acquire any right in a contract. Correct, right? Who cannot acquire the rights? A stranger or a third party. So because they don't have any rights and obligation, can they interfere and sue the parties to a contract? The answer is no. I repeat, privity of contract, doctrine of privity of contract provides that a stranger to a contract cannot sue. Why? Because a contract is a private relationship between the parties and no other person can acquire rights and liabilities, hence they cannot file a suit. But there are exceptional cases where even though a person is a stranger but still he can enforce the rights available in the contract. What is the first one? In case of beneficiary of a trust. In case a trust is created for the benefit of somebody, the beneficiaries can file a case against the parties to the contract, against the trustee. Next one, in case of family settlement. If settlement is in writing, so the members who is not a party to the contract can also enforce it. Brothers made a promise to pay money to the mother. Even though mother has not signed the document, still she can enforce the right against the son if they don't pay the promised amount. So family settlement in writing, even if the member who is not a party to the contract can enforce it. Next one, in case of certain marriage contract or arrangement, any provision made in the contract for the benefit of a person, the person for whose benefit the provision is made can enforce the contract. Next one, in case of assignment of contract, who can file a case? The assignee can file a case. What is assignment, sir? Transfer of rights by one person to another person through an assignment deed is called as assignment. In case of assignment, who can file a case? Assignee can file a case. Next one, acknowledgement or estoppel. If a person make an acknowledgement of his liability or admission of liability to a third party, then third party can file a suit based upon the principle of estoppel. When you admit your liability, you cannot deny it later. So in that case, who can file a case? Third party can file a case. Next one, covenants running with the land. What is covenants? Are conditions. Any conditions imposed on the land are always transferred along with the land. So the subsequent buyer, even though he is not a party to the contract, he is bound by the covenants which were imposed in the original contract. Because those conditions always run with the land. If it is with me, I am bound by it. If it is with X, X is bound by it. If it is with Y, Y is bound by it. Next one, contract entered through an agent. Obviously, any contract made through an agent, there will be a privity of contract between the principal and the third party. Who can file a case? Principal can file a case against the third party to recover the money to be paid to him. So these are the 7 exceptional cases where who can file a case? A stranger or a third party can file a case against the parties to a contract. Clear? Next one, we have the parties who are incompetent to contract. Section number 11. Section number 11 provides what? Parties who are incompetent to contract. Who are the parties incompetent to contract? 3 categories of person: minor, unsound mind, disqualified by law. Who is a minor? The definition of minor is given in the Indian Majority Act 1872. Who is a minor? In the normal cases or general cases, anyone who has not attained the age of 18 years is considered as minor. Then who is minor, sir? The one who has completed 18 years of age is considered as what? A major. Then who is a minor in special cases, sir? That is where the court has appointed a guardian. If natural guardian is not there and the court has appointed a guardian, in that scenario, a person becomes the major at what age? 21 years. General cases 18 years, special cases 21 years. Law with respect to minors agreement. Any agreement with minor is what? Void ab initio, void from the beginning itself. For this, what is the case name? Mohiri Bibi versus Dharmadas Ghosh. Remember what case deed by a minor in favor of a major. Agreement is void, not enforceable by law. Once void, always void. No ratification after attaining majority. If a minor becomes a major, enters into a new contract, to ratify the contract which was made when he was a minor, is it valid, sir? No, because there is no new consideration. Sir, can he make a new contract with new consideration once he becomes a major, sir? Yes. But can he ratify the old agreement? No. Next one, minor can be a beneficiary or can take benefit of a contract. If there is a contract which contains only benefits in favor of the minor, is it valid? Yes. Minor can sue major. Major cannot sue minor. So, if a major takes a loan from a minor by giving his house as security, can minor enforce it against the major? Absolutely yes. Next one, minor can always plead minority. The principle of estoppel is not applicable against the minor. If a minor borrows a loan or enters into a contract by misrepresenting his age, by misrepresenting his age, is that contract valid? Yes, the contract is void, not enforceable by law, because a minor can always plead a minority. If a minor misrepresents his age and enters into a contract, still that agreement is void because a minor can claim his minority. But however, if a minor has received any money by misrepresenting his age, and if the money is not spent, the court at its discretion, in the interest of justice, may order the minor to restore the cash back to the other person who has given the loan. But however, minor can never be personally held responsible because any agreement with a minor is void, and minor can always plead what? Minority. Fifth one, liability for necessaries, section number 68, important. Minor is not personally liable, but what is liable? Minor asset is liable. So minor is liable for necessaries but not personally liable. Only what is liable is property is liable. So what is necessary items, sir? Necessary item means which are essentially needed by a minor, are the items which a reasonable man would supply to an infant in that particular class to which the minor belongs. So if a person supply necessary items to a minor, he can recover the money out of minor's asset, not from the minor, because a minor can never be personally held responsible even for necessary items. Contract by the guardian. If a guardian makes a contract on behalf of the minor within his competence for the benefit of a minor, is it valid? Yes, it is valid. But however, a guardian cannot transact in immovable property on behalf of a minor without the approval of court. Means he cannot purchase, he cannot mortgage, he cannot dispose the assets of the minor without the consent of the court. Other than that, a guardian within his competence for the benefit of a minor, he can make a contract and the contract is valid. Next one, no specific performance. A minor cannot be compelled to perform what he has promised because he is a minor. And there cannot be any personal liability on the part of whom? Minor. He cannot be insolvent. First, let him become major and then he can claim insolvency. Partnership, can he be a partner? No, he can only be a beneficiary. Under section number 30 of the Indian Partnership Act, a minor can be admitted to the benefits of the partnership. Next one, can he be an agent? Yes, absolutely, a minor can be an agent. Who can be an agent? Even minor can be an agent without binding himself to whom? Principal. It means if minor does something on behalf of the principal to third party, who is responsible? Principal is responsible. But if minor does any mistakes while acting as agent of principal, can principal sue minor? No. Next one, contract cannot bind the parent or guardian. See, for the act of minor, who is not responsible? Parents are not responsible. Based on this, they asked question in the previous examination. Srishti, laptop. In the absence of authority, either expressed or implied, given by the parents or a guardian, for the act of a minor, even if for a necessary item, who is not responsible? Parent or guardian are not responsible. What if authority is given, either expressly or impliedly? Are the parents are responsible? Yes. Next one, joint contract by minor and major. Who is responsible? Major is responsible. Contract is valid. Surety for minor. Is the contract valid? Yes, because surety is there, contract is valid. Who will be responsible? Surety is responsible. Minor as shareholder. Can minor be a shareholder? No. Even if his name is entered by mistake, it can be removed from the register of members. But however, a minor can be a transferee of shares if the shares are fully paid. Next one, liability for tort. Remember this. Tort is different. Breach of contract is different. If there is a breach of contract by minor, is he liable? No. But tort, yes. What is tort, sir? Tort is a civil wrong like battery, assault, defamation. These are called as what? Tort. So a minor can be held responsible for tort, not for breach of contract. These are the provisions with respect to what? Minors agreement. Next one, section number 12, persons of unsound mind. Section number 12 defines who is sound mind. If at the time of contract, if a person is capable of understanding the term and can form the rational judgment as to the effect of the contract upon his interest, that is called as what mind? Sound mind. Means at the time of contract, he is capable of understanding it and forming the rational judgment, a sane judgment upon his effect, upon his interest. Then he is called as sound mind. Otherwise, he is called as what? Unsound mind. Example, lunatic, idiot, drunken, a person who is enfeebled by the age. These are a person who is delirious from the fever. These are called as unsound mind. If an unsound mind make a contract when he is of unsound mind, is the contract valid? No, contract is void. Void ab initio. But however, section number 68. If any necessary items are supplied to the unsound mind or the person whom he is legally bound to support, the assets of unsound mind is responsible. Section number 12. Capable of understanding, forming rational judgment. Contract is valid. Contract by disqualified person. There are few persons who are disqualified by the law itself. First one is whom? Alien enemy. When there is a war between the two countries, the opposite country citizens are called as what? Alien enemy. So any contract or agreement with alien enemy is what? Void, not enforceable by law. Second one is whom? Foreign sovereigns, diplomats, ambassadors. Any contract with the foreign sovereigns, diplomats, ambassadors is not enforceable in India. Why? Because they are not subjected to local jurisdiction. Because they are not subjected to local jurisdiction of the laws, even if you make a contract with them, it is not enforceable by law. Hence, they are disqualified by law. Next one, company or corporation. See, company is an artificial person. It can make contract. But however, if the contract is made beyond the powers of the company, is the contract valid? No, because Companies Act provides that any agreement or contracts made by a company which ultra vires the company are void, not enforceable by law. Insolvent, during the course of his insolvency petition or proceedings, he cannot enter into a contract. Next one, convict, the person who is under the imprisonment. During such time, he cannot enter into a contract. So these are the persons who are disqualified by law. Section number 11 provides the parties who are incompetent to contract. Minor, unsound mind, persons who are disqualified by law. 11 minor, 12 is sound mind. 13 consent. Two persons agree to same thing in the same sense, there is a consent. So when can we say there is a consent, sir? Two persons deemed to have consented to something when they agree to what thing? Same thing. In what sense? Same sense. There must be a consent, and consent should be what consent? Free consent. Sir, when can we say a consent is free, sir? If it is not caused by what? CUFM square. On what date? August 15th. What is C, sir? Coercion. U, undue influence. F, fraud. M, misrepresentation. Again M, mistake. So if the consent is not obtained by using coercion, undue influence, fraud, misrepresentation, mistake, it is not called as what? It's called as free consent. If it is obtained by using coercion, undue influence, fraud, misrepresentation, mistake, it is not called as a free consent. So there has to be a free consent. And when it is not a free consent, if there is a coercion, undue influence, fraud, misrepresentation, mistake. Let us discuss what is coercion. Section number 15 provides the word what? Coercion. What is coercion? Committing or threatening to commit any act forbidden by IPC, Indian Penal Code 1860. Either you are doing it or making a threat to do it. Any activities forbidden by IPC, for example, kidnapping, rape, or murder, all these are forbidden by IPC. You make a threat to do such activities, takes consent, coercion. Or unlawful detaining or threatening to detain any property to the prejudice of any person. What is prejudice? Against the interest of any person with the intention of causing any person to enter into a contract. It is also called as what? Coercion. There are two parts here. One, an act forbidden by IPC. Second one, detention of a property of a person unlawfully. For example, after the remuneration is paid by principal to agent, the agent shall return all the documents and the goods which are with him and which belongs to principal. If he does not return, or if he refuses to return, and he keep them unlawfully and obtain the consent of principal for payment of extra money, is the consent of principal free or not free? Not free, because he has detained the properties unlawfully. Keep this in mind. There are three scenarios: threat to commit suicide, coercion; threat to go on a strike, not a coercion, because strike is not an unlawful activity or not forbidden by IPC. Threat to file a suit, not a coercion, but a threat to file a false case, coercion. And coercion can be done in India or outside India, it doesn't matter. And what is the effect of coercion? The contract becomes voidable at the option of person whose consent is not free. Section number 15. Section number 16, undue influence. What is undue influence, sir? Where the relationship between the person is such that one person in a position to dominate the will of other person and takes the unfair advantage of it. That is called as undue influence, unwanted influence. It is also called as mental coercion. Coercion is called as duress or menace in England. Undue influence is also called as what coercion? Mental coercion. So we can say that there is undue influence if there are four things. What is the first one? There must be a relationship between the parties. Relationship hona hi chahiye. Relationship irlebeku. But in case of coercion, there is no requirement of relationship. It can be done by parties to a contract or by a stranger also. So there has to be a relationship, a near relationship between the parties, like father and son, daughter and mother, like this. And in that relationship, one person in a what position? A dominant position, a position to dominate the will, and the other person in a weaker position. And the person who is in a dominant position takes the what? Unfair advantage of it. Then we can say there is undue influence. And in case of undue influence, the burden of proof will be on whom? On the party who is in what position? A dominant position. And there are few relationships where law itself presumes that a person in a position to dominate the will of other person. When, sir? When one person has a real or apparent authority over the other person, then we can say that the person having authority is in a dominant position. Sir, having dominance is wrong, sir? No, sir. Having dominance is not wrong. Taking that dominance for an unfair advantage is wrong. Next one, fiduciary relationship. So what is fiduciary relationships are based on trust. For example, income tax officer and the client, and the assessee, and between the CA and client, who is in dominant position here? CA, because client trusts the CA. Fiduciary relationship between trustee and beneficiary. Trustee, between religious guru and disciple. Religious guru, because they are based upon what? Trust. Next one, mental distress. If one person is mentally distressed, other person is normal, then the person who is in normal capacity is presumed to be having what? Dominance. Next one, unconsignable transactions, where the interest charge is unreasonable, beyond the reasonability. Then also we can presume the dominance of will. Okay? So is that clear? So in case of dominance of will, who has the burden of proof? The opposition party. That the person who is in a dominant position will have the burden of proof to provide that evidence that he was taken the consent of the other persons at his free will. If he could prove that, he will win the case. Otherwise, the other party will succeed. And हम लोग discuss किया था. I have discussed that in case of consideration, if it is shockingly less, the court can take that fact that the consideration is shockingly less as an evidence in case of allegation of consent not being paid. Effect of undue influence, section number 19A provides the provisions with respect to effect of undue influence. The contract becomes voidable at the option of aggrieved party, and the contract may be set aside absolutely, means entire contract can be considered as void, or if the party who is having a right to cancel it, if he has received any benefit, then the court can enforce it upon such terms as it seems fit or seem just or equity. For example, a person has taken the loan and he has taken the loan at a rate of 25%, unreasonable one. So because the person who has a right to cancel it already received some benefit, What court can do? It can enforce the contract subject to modification. Like court can say pay reasonable interest, 10%, 12%, valid. So in case of undue influence, the contract can be set aside absolutely, or if the person having a right to cancel it has received some benefit, subject to modification, which justice requires. Section 17, most important one. What is fraud? Following acts are considered as fraud when following acts are committed by a party to the contract or by his agent with the intent to deceive the other party or his agent to the contract. It is considered as what? Fraud. There are 5 cases which are considered as fraud. First one, suggestion as a fact of that which is not true by one who does not believe it to be true, means intentionally lying is called as fraud. When a person suggests something as a truth which is not true and he does not believe it to be true, means what? He knows that whatever he is saying is lie. That is considered as fraud. Second one, active concealment of a fact by a person having the knowledge of it. A person is aware about a particular fact, the truth, but he conceals it. A person is having a disease, he conceals it and get married. Fraud. Third one, any promise made without any intention of performing it, a fake promise. A person makes a promise and he doesn't have any intention of performing it, like promise to marry a girl, promise to repay the debt. These are all considered as what? Fraud. Fourth one is a general provision which covers the other sections, like where an act is not covered under the first one, second one and third one. It comes under which one? Fourth one, any other act fitted to deceive. And the last one is what? Any act or omission which a specific law declares as fraudulent. If there is any other law which states a particular act as a fraud, it is also considered as fraud. As per which act? The Indian Contract Act 1872, section number 17. For example, Companies Act provides that any misstatement in the prospectus is punishable as a fraud. So it is also fraud as per which act? Contract Act. Next one, mere silence is not a fraud. Why? Because there is no obligation upon the seller or the person to disclose the whole truth or the information which he is aware of, because let the buyer be aware, caveat emptor, the buyer should be careful enough, should be diligent to purchase the goods which is suitable for him. It should be careful. If there are flattering truth and if he fails to exercise the due diligence and he makes a wrong choice or he purchases the wrong goods, who is not responsible? Seller is not responsible. So silence is not a fraud. I have some information that share market will go up after the election result, and if I don't disclose it, and if I sell the shares at a high if I purchase the shares at a lower price and other person is not aware about the information, sell them at a lesser price, can he claim a fraud here? No, because nobody is under absolute duty to disclose everything. So if there is no duty to speak as per the law or as per an existing contract, silence does not amount to fraud. Keep this in mind. If there is no duty to speak upon a person, then silence does not amount to fraud. But what if there is a duty to speak, sir? Then it amounts to fraud. Generally, silence does not amount to fraud. But if there is a duty to speak upon a person as per the law, in that scenario, silence amounts to what? Fraud. Sir, in what type of contract or what type of situation there is a duty to speak, sir? First one, in case of contract of fiduciary relationship. Second one, contract of insurance. Sir, what is fiduciary relationship, sir? Based on trust. Second one, contract of insurance, contract of marriage, contract of family settlement between the family members, and share allotment contract. In these 5 types of contract, and also in case of immovable properties to some extent, there is a duty to speak. In these cases, if a person remains silent even though he is aware about the material facts, that amounts to what? Fraud. Next one, where silence itself equivalent to speech. There are cases where a person's silence also is equivalent to speech. For example, if a person says, if you do not deny something, I will consider it as a good product. He remains silent. By remaining silent, he is admitting that it is of what quality? Good quality. If it is not of good quality, it amounts to what? Fraud. Effect of fraud, same like other one. In case of fraud, the contract can be rescinded at the option of whom? The person whose consent is not free. He can file a suit for what? Even damages. Section number 18, misrepresentation. Simple. Intentional misstatement, fraud. Innocent misstatement, misrepresentation. If a person suggests something as a fact which is not true by one who does not believe it to be true, it is called as fraud. If a person suggests something as a fact which is not true, which he believes it to be true, is called as misrepresentation. Why? Because he is also innocent. So there are three parts in the definition of misrepresentation. The first one, any positive statement not warranted by the information which is not true, though he believes it to be true, is called as what? Misrepresentation. Second one, breach of duty. First one is any positive statement which is not warranted by his information, he is not aware about it, which is not true, but he believes it to be true. Misrepresentation. Breach of duty without intent to deceive, gaining advantage to one person and loss to the other person, considered as misrepresentation. Keep this in mind, there should not be intention to deceive. Next one, causing innocently a party to a contract to make a mistake as to substance which is subject of the agreement. That is also considered as what? Misrepresentation. Effect of misrepresentation, the aggrieved can avoid or resign the contract and he can also insist upon the performance. But can he claim damages? No. But in case of fraud, can he claim damages? Yes. And there are three exceptional cases where even though there is a misrepresentation, the contract cannot be resigned. They asked question based on this in the many times in the previous examinations. The contract cannot be resigned in the following cases. What is the cases? First one, where after being aware about misrepresentation, if a party takes the benefit of the contract or if he affirms the validity of the contract, he cannot cancel it. You purchase a goods which is not according to your expectations or statements made by the seller, and you start using it, consuming it. Can you cancel it later? No. Second one, party could have discovered the truth by ordinary diligence. Where a party could have discovered the truth by ordinary diligence, but he fails to exercise the due diligence. Can he cancel it later? No. We have discussed this example of providing the accounts where the true amount is mentioned, but other person does not inspect it. He cannot cancel it. Last one, restoration of parties to the original position. If it is not possible, there was a misrepresentation and it is not possible to bring the parties to their original position. Restitution is not possible. In that scenario, the contract cannot be cancelled. These are the three cases where a contract cannot be cancelled. What is the first one? Aware of misrepresentation, takes the benefit or affirms the contract. Party could have discovered the truth by ordinary diligence, cannot be cancelled. Or where the restoration of parties to the original position is not possible. In these three cases, the contract cannot be resigned, even though there is a misrepresentation. Next one, mistake, section number 20, 21, 22. An innocent or erroneous belief by the parties to the contract, or which parties misunderstands, is called as what? Mistake. A wrong belief, a erroneous belief is called as mistake. Mistake can be of how many types? Two types. Mistake of law, mistake of fact. Mistake of Indian law, the contract is valid. Why? Because ignorance of law is no excuse. Everyone are presumed to be aware about the law. If a person has a wrong belief about Limitation Act, made a promise to pay the time barred debt, is it valid? Yes, it is valid. Mistake of foreign law, you shall consider it as what? Mistake of fact. You shall consider it as what? Mistake of fact. It is same like mistake of fact. If it is unilateral mistake, contract is valid. Bilateral mistake, the contract is void, because nobody is expected to know the foreign laws. Mistake of fact, it can be of how many types? Two types. Unilateral mistake, valid. It can be about identity or about nature, then it is void. See, generally, if one party under mistake, let the buyer be aware, the contract is valid. It cannot be cancelled. You want to buy something, you buy something else. Can you cancel it? No, it's your problem. But however, if there is a mistake about identity or about nature of contract, is the contract void? Yes, it is void, not enforceable by law. For example, a old lady thinking that she is signing a rental agreement. She signed a transfer deed. Is it valid? No, it is void. Bilateral mistake, agreement is absolutely void. Why? Because there is no mutual consent. There is no meeting of minds. This bilateral mistake can be about quantity, quality, identity, price or title. So if there is a bilateral mistake, the agreement is void, not enforceable by law. Section number 22. Next, section number 23. Section number 23 provides what? Lawful object and consideration. To be a valid contract, object must be what? Lawful. If the object is unlawful, is the agreement valid? No, agreement is void, not enforceable by law. Section number 23 provides Section number 23 provides the lawful object and consideration. So, to be a valid contract, the object must be what? Lawful. If it is unlawful, the agreement is void. There are few cases where the object is considered as unlawful. Because the object is unlawful, the agreement is void. What are the cases? The first one, if the consideration or object is forbidden by law or prohibited by law. If the consideration or object is prohibited by law, then it is considered as what object? Unlawful object. So when can we say the consideration is forbidden by law? If it is an act, it is considered as forbidden by law. If it is punishable under any statute, or if it is prohibited by regulations or orders made under the powers given under the statutes. See, restrictions are different, prohibition is different. If it is prohibited, unlawful object. If it is restricted, it is not considered as unlawful object. For example, a license by the forest officer, subject to restriction. If it is transferred, not considered as unlawful object. Only if it is forbidden, it is called as unlawful object. So first scenario when it is considered as unlawful is when the consideration or an object is forbidden by law. Second one, a consideration or an object is of such nature if it is permitted would defeat the provisions of the law or purpose of the law. It is like if a person try to do something indirectly which he cannot do directly, or if you go against the provisions of the law, such kind of objects are not enforceable in the court of law. Why court will not enforce it? Because if they enforce it, it will defeat the law or it makes the law meaningless or a provision meaningless. That is why such kind of objects are considered as unlawful object. For example, if there is an agreement between the parties not to plead limitation, where person has agreed you can file a case whenever you want. Is that agreement valid? No, it is against the what? Limitation Act. It becomes useless. Next one, adoption for annual maintenance. See, as per Hindu law, Hindu Adoption Act, there can't be any consideration for adoption. What if a person has indirectly promised to pay some maintenance? Valid? Not valid. Transfer of bus permit is prohibited. So to avoid that provision, what they have done, they made a partnership between the person having license and the person not having license. Is the partnership valid? No, because any consideration or object is such nature that if permitted, it would defeat the provisions of the law or purpose of the law. It is considered as unlawful. Next one, where a consideration or object is fraudulent, means what? To promote the fraud. If partnership agreement is made with the intent to defraud the public, is that agreement valid? No, agreement is what? Void. Any agreement where the intention is to cheat or defraud the public or any other person, agreement is void. Why? Because the object is unlawful. First one, forbidden by law. Second one, if it defeats the purpose of the law. Third one, if it is fraudulent. And the fourth one, if the consideration or object involves injury to the person or property of another. Because of your agreement, it gonna spoil or it gonna infringe the rights of somebody else. It is considered as what? Unlawful object. Injury is a what? Criminal or a wrongful act. It is considered as injury. For example, you made a contract to copy the movie of somebody or a book of somebody. It's a violation of copyright of somebody. So that agreement is not enforceable by law. Or an agreement for a manual labor for repayment of debt. Is it valid? No, because it's gonna impose an injury upon the person. So any consideration or object involving injury to the person or property of another, it's considered as unlawful object. Next one, if a consideration or object is immoral against the public morality, unlawful object, hence the agreement is void. Example, a loan to a married woman for a written promise to get a divorce and get married to the person who is giving a loan. Valid? No, it is immoral, opposed to public morality. Next one, consideration or object opposed to public policy. Now, what is public policy, sir? The public policy is a concept which is developed by the court over a period of time. And this concept of public policy is based on what? Precedents, the judgments of the court. There is no specific provision in the Indian Contract Act. These are based on what? Judgment. Anything which is in favor of the public is called as in favor of public policy. Anything which is against the public good is called as opposed to public policy. And first one which is considered as opposed to public policy is trading with enemy. So without license of the government, without permission of the government, if you trade with an enemy during the war, it is considered as opposed to public policy and the object is unlawful, agreement is void. Next one, stippling of prosecution or stifling of prosecution. What is stippling of prosecution, sir? Stippling of prosecution means suspension of the prosecution or suspending the prosecution. It's an agreement to prevent the proceedings already instituted from running their normal course of action by using the what? Force. You try to interfere with the course of justice. You try to avoid the prosecution by an agreement and using force. That is considered as what? Stippling of prosecution. These key words must be there in your answer. Agreement to prevent the proceedings already instituted from running their normal course of action by using the force. It is called as perversion or abuse of justice. Sir, why it is not allowed, sir? Why? Because any person who has committed a crime should be prosecuted and punished. That is the principle of law. If you allow a person to escape after committing a crime, it gives a bad message to society. Everybody start committing the crime. So इसीलिए any agreement not to prosecute or to drop the prosecution is void and not enforceable by law. So what if it is compoundable offence, sir? Yes, it is valid. If it is a non-compoundable offence, it is void, not enforceable by law. Next one, maintenance and champerty. Any agreement where a person promises to maintain a suit in which he has no interest. He just had the intention of promoting litigation. Because of that, he made a contract to finance. Is that agreement valid? Agreement is void. Next one, champerty. What is champerty? Agreement to assist another person in a litigation in exchange of a promise to hand over certain portion of proceeds is called a champerty. Are champerty agreements are valid, sir? No, agreements are what? Void. But what if maintenance and champerty agreements are made in good faith for a valid reasons, bona fide reasons? Is it valid? Yes, valid. Next one, trafficking relating to the public office or titles. Enforceable, not enforceable? Not enforceable because they're opposed to public policy. Why? Because it will interfere with the appointment of a best qualified persons for the public service. So if you sell government job for consideration, it is void, not enforceable by law. Titles for consideration, void, not enforceable by law. Next one, agreement to create monopolies. Valid or void? Void. Why, sir? Because if there is a competition, it benefits from society. More the competition, then better the price. There will be innovations, inventions. So because a monopoly will curtail all these things, so an agreement to create monopoly is what? Void, not enforceable by law. Next one, marriage brokerage agreement. What is marriage brokerage agreement, sir? An agreement to procure a boy for a girl or a girl for a boy for a consideration is also considered as what? Void, not enforceable by law. Next one, interference with the course of justice. If you try to interfere with the course of justice, is that agreement valid? No, agreement is void. Bribing of witness, bribing of registrar of the court, or bribing of judges, all these are opposed to public policy. It is based upon the principle that no filthy hand should be allowed to touch the secret fountain of justice. So any agreement which interfere with the course of justice, void, not enforceable by law. Next one, any agreement creating an interest against the obligation, going against the obligation or a public duty, valid or void? Void, not enforceable by law. That agent example. Agent is receiving money from the principal, should work for whose benefit? Principal's benefit. What if he makes or if he enters into a contract for his own benefit? Valid or void? Void. Opposed to what policy? Public policy. So these are the 8 agreement or 8 scenarios where the agreement is considered as opposite to public policy and the agreement is void. Section number 24, consideration or object unlawful in part. If there is a contract in which part of the consideration is lawful, part is unlawful, and if it is possible to separate lawful part valid, unlawful part is void. If it is not severable, if it is not possible to separate, entire agreement is void, not enforceable by law. So these are the cases in which the object is considered as unlawful. So we covered till section number 25. 1. Short title and extent. Section number 2. Definition. 3. The communication of offer and acceptance. Section number 4. When the offer and acceptance communication is complete. 5. Revocation. 6. How to make revocation. 7 is absolute. Acceptance must be absolute. 8. Accept the offer by performing the conditions of the offer. 9. Promise. It can be expressed or implied. 10. Essential elements of a valid contract. 11. Minor. 12. A sound mind. 13 is a consent. 14 is a free consent. 15. Coercion. 16. Undue influence. 17. Fraud. 18. Misrepresentation. 19. Voidable. 20, 21, 22. Mistake. 20 is bilateral mistake. 21. Mistake of law. 22. Unilateral mistake. 23. Lawful object and consideration. 24. If the consideration or object is unlawful in part, possible to separate, lawful part is valid, not possible to separate, entire agreement is void. And section number 25. Any agreement without consideration is void, but there are exceptions where even though consideration is not there, the agreement is valid and enforceable by law. Discuss the void agreements now. Section number 26 provides the provision with respect to agreement in restraint of marriage. So any agreement which restrain a person from marriage is void except with a minor. So because minor cannot get married until unless he becomes a major. So if you make an agreement to restrain a minor from getting married, agreement is valid and minor can enforce it. But any agreement with a major is not enforceable by law. Because restrictions can be partial restriction or it can be an absolute restriction. To marry not to marry a particular person or not to marry anyone for a particular period or for a whole time. Such agreements are void, not enforceable by law. Section number 26, agreement in restraint of marriage is void. Section number 27, agreement in restraint of trade. Any agreement which restrains a person from doing or carrying a lawful business or a profession or a trade, the agreement is what? Void, not enforceable by law. I repeat, section number 27 provides that any agreement in restraint of a business or a trade is what? Void, and based on this, they asked a question in the recent MTP, 2024 May MTP. Any agreement in restraint of a business or a trade is what? Void. But are there any exception? Yes. What are the one of the exception? Sale of goodwill. In case of sale of goodwill, and if in case of sale of goodwill, where the seller sells the goodwill and agrees with the buyer to refrain from carrying the similar business. Important. What business? A similar business within the specified local limits. As long as the buyer or successor in interest carries the business, is that a restriction valid? Yes, it is valid. Where the seller is restricting himself from carrying the similar business within a specified local limits unless the buyer or his successor in interest is carrying the business. Such restriction is valid. First exception, sale of goodwill. But this local limit must be what? Reasonable. Second one, partnership agreement, section number 36. If a retiring partner, an outgoing partner may be restrained from carrying what business? Similar business by an agreement. Is that agreement valid? Yes, it is valid. Section number 11 provides that the partners may agree to not to carry any competing business outside the firm. Is such agreements valid? Yes, it is valid. It is an exception to the section number 27 of the Indian Contract. Next one, service agreement, where employee binds himself during the term that he will not compete with the employer or not to work anywhere else. Is the agreement valid? Yes, it is valid, even though it is restraining a person from carrying a lawful business, profession or trade. Last one, solace agreement or franchisee agreement. In case of solace agreement or franchisee agreement, the person who is giving the franchisee may restrain the person who is buying the franchisee from dealing with any other goods. Is that agreement valid? Yes, it is valid. So in general, section number 27 provides that any agreement in restraint of business or trade is void. But there are 4 exceptions. First one, sale of goodwill. Second one, partnership agreement. Third one, service agreement, and the fourth one is solace agreement or franchisee agreement. Section number 28, agreement in restraint of legal proceedings. See, ubi just ibi remedium. Where there is a right, there is a remedy. Every person has the right to go to the court of law and enforce his right. Because with a right without remedy is useless, right? So what if the parties by an agreement restrict themselves absolutely from enforcing the legal right? Is that agreement valid? No, agreement is void. So in an agreement where one party is restricted absolutely from enforcing his right to the court of law, is that agreement valid or what? Void, not enforceable by law. What if it abridges the usual period for starting the legal proceedings? As per Limitation Act, what is the usual period? 3 years. Now, what if the parties by an agreement reduce it to 2 years? Is that agreement valid? No, agreement is void. I repeat, any agreement by which one party is restricted absolutely from enforcing the right to the court, or where the parties abridges the usual period for starting the legal proceedings, such agreements are void. But the exception is arbitration agreement. Means whereby an agreement parties agreed to refer their dispute to the arbitration, not to the normal court. Is that agreement valid? Yes, because they're not restraining the parties absolutely. They're just saying instead of going to the court, they will go to whom? Private parties who are called as arbitrator. Is that agreement valid? Yes, it is valid. Other than arbitration agreement, if you restrain a person absolutely from enforcing the right to the court of law, valid or void? Void. Next one, section number 29. Agreement where the meaning is uncertain. Agreement is void, not enforceable by law. Section number 30, wagering agreement. What is wagering agreements or wagering agreements? Wagering agreements means it's an agreement where money or money's worth is payable by one person to another person upon the happening or non-happening of an uncertain event. It's a game of chance. Is the agreement valid? No, agreement is what? Void. There are few transactions which are similar to the wagering agreements and they are void. Example, lottery transaction, prohibited, it's also punishable, but in Kerala it is allowed. Next one, crossword puzzle and competitions with pre-prepared answers with the publishers, wagering agreements. Next one, speculative transactions, wagering agreements, horse race, wagering agreement. But there are few things which are resembles the wagering agreements, but they are valid. What are these? Are chit fund if it is registered, valid. Share market transactions, speculative. People are speculating that if a Modi government secures a majority, then the market will shoot and people are buying more number of shares. Next one, game of skill and athletic competitions to the extent of 1,000 rupees prize money, valid. Next one, contract of insurance is also valid. Section number 30. नेक्स्ट सेक्शन नंबर 37 से शुरू होता है परफॉर्मेंस ऑफ कॉन्ट्रैक्ट. इंपॉर्टेंट. Most of the questions will come out of this part. Why? Because this is where the breach of contract provisions will come into picture. Okay, 37 simple hai. 37 perform, both party perform. If you remember in our song, 37 perform, both party perform. Obligation of the parties to the contract to perform. Section number 37 provides that the parties to the contract shall either perform or offer to perform their respective promises unless the performance of such promise is dispensed with or excused under the provisions of this act or any other law. It just provides that it is the obligation of the parties. You should perform or offer to perform your respective promises unless the performance is excused either by the existing law or either by the contract or by any other law. And the promises made in the contract also bind the representative of the promisor in case of his death, unless a contrary intention appears in the contract or anything else is agreed in the contract. Section number kya hai? 37. Wherever there is a question of breach of contract, you must write section number 37 because 37 is the obligation section, like charging section in case of income tax. Section number 37 provides that the parties to the contract shall either perform or offer to perform their respective promises unless the such performance is dispensed with or excused under the provisions of this act or any other law. And the promises bind the representative in the of the promisor in case of death of the promisor before the performance such promise. Next, section number 38, refuse, promissory refuse, effect of refusal to accept the offer of performance. If the promisor is ready and willing to perform, if the promisee does not accept it, then who is not responsible? Promisor is not responsible. Then who is responsible? Promisee. So promisor is not responsible for the breach of contract, nor he will lose any of his rights, provided The offer to perform by the promisor must satisfy how many conditions? 3 conditions. It must be unconditional at a proper time and place. If it is to deliver something, then there should be a reasonable opportunity to inspect the goods should be given to the promisee. 39, section number 39. 39 refuse, promisor refuse, breach of contract. Wherever there is a question of breach of contract, you should write section number 37, section number 39. If the party to the contract refuses to perform or disabled himself from performing the promise in its entirety, the promisee may put to the end to the contract, means he can resign it unless he has signified his acquiescence in the continuation of the contract either by his words or by conduct. I repeat, if the promisor refuses to perform the contract or disables himself from performing the promise in its entirety, the promisee may put the end to the contract. But what if he has signified his acquiescence, means admission in the continuation of the contract, either by words or conduct? Can he cancel it later? No. For this, we have a singer example where she made a promise to sing every week. First week she absents, second week she turns up, and the other person accepts it. Can he cancel it later? No, because by allowing her to sing in the next day, he has given the acceptance for continuation of the contract. Section number kya hai? 39. Next, section number 40. Section number 40. Who shall perform the promise? 37. Duty of the party. 37. Perform, both party perform. 38. Refuse, promisee refuse. 39 refuse, promisor refuse. 40 perform, who shall perform? The contract shall be performed by the promisor himself. First is what? Always the promisor. If something is there in the contract to show that it is the intention of the party that the promise should be performed by the promisor himself, then it should be performed by the promisor. Or where the personal consideration is the foundation of the contract, it should be performed by the promisor. Other than that scenario, if personal consideration is not the foundation of the contract, then the promisor or his legal representative can employ a competent person to perform the contract. Next one, if a contract does not involve personal skill and if the promisor dies, who shall perform the promise? The promisor's legal representative. But however, the liability of the legal representatives is limited to the extent of property inherited. Next one, third party perform, section number 41. If a promisee accepts the performance from third party, he cannot later enforce it against whom? Against the promisor, because it results in discharge of whom? Promisor. If a third party perform the contract and the promisee accepts it, later he cannot demand performance from the promisor, because once he accepts the performance from the promisee, it results into discharge of the promisor. Next one, section number 42. Devolution of joint liabilities 42, 43, 44, 45 deals with joint promises. So whenever the question is with respect to joint promises, your answer should start with the word called as two or more persons, where two or more persons are made a joint promise. Unless the contrary intention appears from the contract shall be performed by whom? All the joint promises during their joint lives. If in case of death of any of the promiser, then his representative jointly with survivor. In case of death of last survivor, representative of all jointly should perform the contract. 42 perform, 42 JP, joint JP. 43, in case of section number 43, there are three provisions, okay? In case of joint promises, where there are two or more persons have made a joint promise, unless the contrary intention appears, the promisee may compel any one of the promiser to perform the promise. Where two or more persons made a joint promise, the promisee in the absence of contract to the contrary may compel any one or more joint promiser to perform. Then each promiser may compel contribution from the other promiser. The joint promiser may compel other joint promiser to contribute equally with himself. Correct, right? See, if promisee compels any one of the promiser to perform, then the promiser who has been compelled to perform in its entirety can compel the contribution from the other promiser. And at the same time, the third provision is the sharing of loss in case of default of contribution. If one of the two or more joint promisers make a default, the remaining promiser must bear the loss in what share? Equal shares, equal ratio. Section number 43, 3 provision. Promisee can compel any one of the promiser to perform. Then the promiser can compel the contribution from other promisers. Then in case of loss by default of any of the promisor should be shared by the remaining promisors jointly. 44 effect of release of one of the joint promisor. If the promisee releases any one of the joint promisor, it will not release whom? Other joint promisor, nor it will discharge the joint promisor so released from the responsibility towards whom? Towards the joint promisors. If there are three promisors A, B, C, A is released. Does it mean B and C also released? No. It doesn't also mean that the one who is released from his obligation towards the other joint promisor. He continues to be liable to the co-promisor. 45 in case of joint rights, joint promises. If there are more than one joint promises, then all of them can enforce the contract during their joint life. In case of death of one of the joint promisers, the remaining joint promisers along with the legal heads of the deceased joint promisee. In case of death of the last survivor, all the joint promises can enforce the contract against the promisor. I repeat, where a person promises to do to some two or more person jointly, then those joint promises can enforce the contract jointly when they are alive. If anyone dies, remaining joint promises along with the legal representative of the deceased joint promisee, in case of death of all of them, all legal heads of the deceased joint promises can perform or demand the performance from the party. Then 46 to 50, time and place of performance. 46 provides a situation where no application to be made by the promisee, means he has agreed to perform without any request by the promisee, and no time is specified. In that case, it has to be performed within what time? Reasonable time. Section number 46, time and place where time is specified, no application is to be made. During what hours? Usual hours of business. 48 is the case where promisee should ask the promiser to perform, means the promiser has not undertaken to perform the promise without a request from the promisee. Then it is whose responsibility? Promisee responsibility to make an application to the promiser to perform the promise at a proper place within a reasonable time during the business hours. 49, no application to be made and no place is fixed for the performance. Then the promiser shall request the promisee to fix the reasonable place for performance of the contract. 50 is most important. Performance in a manner or a time prescribed or sanctioned by the promisee. Any performance done in a manner accepted by the promisee or time prescribed by the promisee is valid even though it is not in accordance with the promise made, because a promise can be performed in any manner which is sanctioned by the promise. That is considered as a valid performance. Section number 46 to 50. 51 to 58 deals with what? Performance of reciprocal promises. What is reciprocal promises? Where there is a promise for a promise, it is called as what promise? Reciprocal promise. 51 RP, simultaneous RP, means if there are simultaneous promises, there is a reciprocal promises to be performed simultaneously, then the promiser need not perform his promise unless the reciprocal promise is ready and willing to perform his promise. Next one, 52, order of performance of reciprocal promises. The reciprocal promises to be performed in the order fixed in the contract. If the order is not fixed expressly, then the order which the nature of transactions requires. I have discussed many examples for this. If order is fixed, in the fixed order. If it is not fixed, then in the order which the nature of transaction requires. 53, liability of the party preventing the event on which the contract is to take effect. Remember, when the contract becomes voidable, one of the scenario is section number 53. If one party prevent the event on which the other party is supposed to perform the contract, the person who is so prevented can cancel the contract. Section number 53. 54, dependent RP, where there are reciprocal promises and it is such that one of them cannot be performed till the other has been performed, and the promiser failed to perform his promise, then he cannot claim the performance of reciprocal promise, obviously, because if he don't perform, I cannot perform, and he fails to perform. Can he demand performance from me? No. And I can still file a case against what? Other person for compensation. Then 55, failure to perform the reciprocal promise, where time is the essence. The contract becomes voidable at the option of the other party. Section number 56, agreement to do impossible act. Any agreement to do impossible act, valid or void? Void, because one of the essential of valid contract is it must be possible to perform. This impossibility can be initial impossibility or supervening impossibility. What is initial impossibility? Impossibility persists from the date of entering into a contract itself. Agreement valid or void? Void. If it was known to parties, void. Not known to the parties, void. Known to the one of the parties, then the one who is aware about that should compensate the opposite party. What if the impossibility happens after the contract is made? It is called a supervening impossibility, post-contractual impossibility, or subsequent impossibility, or doctrine of force majeure, or act of God. Agreement is what? Void, not enforceable by law. So if a performance becomes illegal or impossible by occurrence of an unexpected event or change of circumstances, is the agreement valid? No. Agreement is what? Void. Enforceable, not enforceable, not enforceable. 57 RP, where reciprocal promises are there to do certain things that are legal and illegal. So whatever the branch which is legal, it is valid. Illegal part is not enforceable. 58, there is alternate promises, one branch being legal, other branch being illegal. Only the legal branch is valid. For example, that rice and opium example, only the rice is enforceable. 59 to 61 ICI most favorite topic, a favorite bachcha hai, favorite magu ide yardu ICI avardu. So appropriation of payment, section number 59 to 61, appropriation of what? Payments. See, simple hai. If a person owes several debts to a single person and he makes a part payment which is not sufficient to discharge all the debt, then how it has to be appropriated? Andre yavudಕ್ಕೆ ಅದನ್ನು apply ಮಾಡಬೇಕು? Towards which debt it has to be applied? It has to be applied as per section number 59 to 61. Section number 59 provides as per the intention of debtor. 60 provides as per the intention of creditor. 61 provides as per the order of time. Section number 59. Application of payment, debt to be discharged indicated. If a payment is made by debtor with either express intimation or implied intimation, that payment should be applied towards a particular debt. Then if the payment is accepted by the creditor, it has to be applied as per whose intimation? As per the debtor intimation. Second one, where the debtor omitted to intimate, or there are no other circumstances to indicate that it is paid towards any debt, then the creditor at his own discretion can apply the payment made towards which debt? Any lawful debt actually due, even for a time barred debt. But however, they cannot apply towards which debt? Disputed debt. Next one, application of payment where neither party appropriates, where debtor fails to indicate as well as creditor fails to indicate. In that scenario, the debt has to be applied in the order of time, first in, first out, and whether it is time barred or not. And where if the debts are of equal standing, means the same debt is borrowed in the same date, two debts are borrowed on the same date. In that scenario, it has to be applied proportionately, proportionate basis or pro rata basis, where we have discussed many questions for this. Clear, right? Next one, section number 62 to 67 deals with what? Discharge of contract, where the contract need not be performed by the parties to a contract. Section number 62 provides the contract need not be performed by mutual agreement in the following scenario. What is the scenario? The parties to a contract may agree to what? Substitute a new contract for the old contract, or to resign the contract, or to alter the contract. In all these three cases, the original contract need not be performed. I repeat, the parties to a contract agrees to substitute a new contract for it, or to resign it, or to alter it, then the original contract need not be performed. So when they agree to substitute a new contract for it, it is called as what? Novation. And novation can happen between the same parties or different parties, but however, consent of all parties is required. Resigned or rescission means what? Cancellation. When they agree to cancel it, what happens? The contract comes to an end. The major difference between the novation and rescission is, in case of novation, a new contract comes into existence, whereas rescission, there is no new contract. But novation also involves rescission, cancellation. Next one, in case of alteration between the parties, which has the effect of bringing the new contract into existence, what is not required to be performed? The original contract need not be performed. So that is why the difference between novation and rescission is very slender, means thin margin difference is there. Next one, section number 63. Promisee may give up, or remit the performance. If a promisee dispense the performance or remit the performance either wholly or part, or he may extend the time for such performance or accept any satisfaction which he thinks fit. In all these cases, who is discharged? Promisor is discharged. I am liable to give 1 lakh rupees cash, but I'll give my watch. Promisee accepts it. I am discharged from the performance of my promise. Section number क्या 63. They ask theory question based on section number 62. Novation, when the contract need not be performed. Section number 62 as well as section number 63. 64. Restoration of benefit under the voidable contract. Any benefit received under a voidable contract by a person who is having a right to cancel it, if it decides to cancel it, must restore the benefit. 65. In the same way, restoration of benefit under which contract? Void contract, where an agreement is discovered to be void or it becomes void. See, it is not applicable for minors agreement because minors agreement is what? Void ab initio. They asked practical question in the previous examination based on section number what? 65. If a contract becomes void or if it is discovered to be void, then the party who has received the benefits must restore the benefits back. Section number 66. Mode for communicating the rescission of voidable contract. If a contract is voidable, the party can cancel it, but he has to communicate the same to the other party. And the communication is complete when it comes to whose knowledge? Other party's knowledge. And the same can be cancelled before it reaches to whom? To the other person. 67. If a promisee fails to provide the reasonable facility for the performance of the contract, then who is excused by law from performance of the contract? Promisor. Because if promisee fails to provide the reasonable facilities, then who is discharged? Promisor is discharged. Then we have certain general topics with respect to performance of the contract, that is discharge of contract. How the contract is discharged or when the contract comes to an end. First one, by performance, when both the party fulfill the obligation, Subhamastu, contract comes to an end. Next one, by mutual agreement, section number 62 and 63, novation, rescission, remission, and waiver. Next one, by impossibility of performance, section number 56, because agreement becomes what? Not required to be performed because it is excused by the law. In case of unforeseen change in law, destruction of subject matter, non-existence or occurrence of particular thing, and declaration of war, the agreement becomes what? It need not be performed, means the contract is discharged. Next one, by operation of law, that is in case of death of a party, contract comes to an end. Unsound mind, contract comes to an end. Next one, by breach of contract. If the promisor refuses to perform and if the promisee resigns it, contract comes to an end. By waiver, section number 63, if a promisee remit or waives the performance of the promise or extend the time or accept some satisfaction other than the promise, discharge. Next one, by merger, when a contract giving the inferior rights gets merged with a contract giving a superior right, which contract comes to an end? Contract giving the inferior right comes to an end. Breach of contract, section number 39. Keep this in mind whenever there is a question about breach of contract, you should write section number 37 as well as section number what? 39. Breach of contract can be actual breach, which happens while performing the contract or on the due date of performance. Anticipatory, before the due date, called as what? Anticipatory breach of contract. In case of breach of contract, what is the remedy available to the other parties? Remedies available. What is the first one? You can file a suit for what? Damages, compensation. Second one, cancellation of contract. Third one, specific performance. Fourth one, injunction. And the fifth one, quantum merit. First one, damages, section number 73. If they ask question about a breach of contract, you should also write about section number 73, the damages available to the aggrieved party. So what is damages? Or how to write the answers for these questions? When the contract has been broken. When what is broken? The contract has been broken. The party who suffers from such breach is entitled to receive from the party who has broken the contract. See, keep this in mind. Frame the wording. Contract has been broken. The party who suffers from such breach of contract is entitled to receive from the party who has broken the contract compensation for any loss or damage which naturally arose, ordinary damages, in the usual course of things from such breach, or which parties knew, most important, To recover the special damages, that losses should be aware about the happening of such loss should be aware to whom? Both the parties. The party should be aware about the special damages when the contract was made. I repeat, when the contract is broken, the party who suffers from such breach entitled to receive from the party who has broken the contract compensation for any or loss or a damage which naturally arose in the usual course of things from such breach, or which parties knew when they made the contract to be likely to result from the breach of such contract. First one is called as ordinary damages, second one is called as special damage. Special damages can be recovered only if it is known to both the parties. No compensation is payable for any remote or indirect losses. Obviously, for this I have discussed a case law where a girl walks in rain and she gets affected with a disease. Can she claim the compensation? No. In estimating the loss, the means existed in remedying the inconvenience should be taken into consideration by the court. Correct, right? If she is traveling in a bus, what is the alternative remedy available? Auto, bike, not the flight. That's right. So these are the rules of damages. Types of damages: ordinary damages, natural losses, special damages, which parties knew when the contract was made. Vindictive as a punishment, available only in case of breach of promise to marry a girl or in case of dishonor of check. Next one, nominal damages, namesake damages, just to record the fact of breach of contract cannot be recovered. Next one, damages for deterioration. Any reduction in the value of the goods due to the fault of buyer or seller should be compensated. Next one, prefixed damages, where the amount of compensation payable in case of breach of contract is agreed by the parties in the contract itself. It is called as what? Prefixed damages. How many types? Two types. What are two types? LD. What is LD? Liquidated damage. Second one is what? Penalty. What is liquidated damages, sir? The reasonable estimate of likely loss. If the parties have agreed in the contract, the reasonable estimate of likely loss from the breach of contract, it is called as what? Liquidated damages. It is a genuine free estimate of the loss and it can be recovered in the court of law. Whereas penalty is just fixed arbitrarily, just fixed randomly. There is no correlation between the loss and the amount fixed. And it is used to threaten a person to perform the contract. And it is unreasonable and cannot be recovered. That is called as what? Penalty. They may ask this question in the examination. Difference between LD and penalty. So, in case of penalty, section number 24, the court will award only the reasonable amount, not exceeding the amounts mentioned in the contract. If the parties have agreed to 1 crore, court will not give 1 crore as compensation. It only gives a reasonable amount. But what if it is loss is more than 1 crore? Will court increase the money? No. So the court will award only the reasonable amount, not exceeding the sum mentioned in the contract. The only exceptional case where the court will give the entire amount mentioned in the contract, even if it is unreasonable, is if the bond is given to central government or state government to perform the public duty or acts in which public are interested. A person has made a promise to the government to perform a public duty, and if he fails to perform, in that scenario, the court can order the person to pay whatever he has promised, even if it is unreasonable. Next one, agreed party can cancel the contract. Third one, quantum merit. What is quantum merit? As much as merited. When a person has done some work, but he could not complete the entire work because of the fault of other party, so he can recover the money for the work he has done. So where a party injured by breach had at all the time of breach done part, but not all the work, can seek the compensation for work done. So it is available in the following cases. When it is available, important, they may ask question in the examination when the quantum merit is available. It is available where the agreement is discovered to be void or it becomes void. If it is something in done, but it is done non-gratuitously. A contract to render services but no agreement for remuneration. First one, agreement is discovered void. Received any benefit, you have to pay for it. Something done non-gratuitously means without any intention of doing it free of cost. You have to pay for it. Contract to render services but no agreement for remuneration, you have to pay for it. Next, party abandons or refuses to perform the contracts. Then he has to pay the compensation to other party. If a contract is divisible and the party not in default enjoy the benefit of the performance, he has to pay for it. If the contract is performed but badly performed, that painting example, party must compensate. Next one, suit for specific performance. When the compensation in terms of money is not the adequate remedy, or when it is impossible to quantify the loss, the court at its discretion may compel the promisor to perform the promise he has made. That is called as what? Suit for specific performance. It is available in case of antique goods and not available in case of minor or contract involving personal skill. Next one, the last remedy available in case of breach of contract is suit for injunction. In case a party is trying to avoid the contract, then the aggrieved party can go to the court and bring an injunction to restrain the person from breaching the terms of the contract. So these are the remedies available in case of breach of contract, section number 1 to 75, but we have not covered section number 31 to 36, that is contingent contract as well as quasi-contract. Usko discuss karta hai. Section number 31 to 36, contingent contract. What is contingent contract? A contract to do or not to do something if some event collateral to such contract does not happen. So here the performance of a contract depends upon the happening or non-happening of a collateral event. So that is called as what contract? Contingent contract. Essentials, the performance of a contract should be depending upon what? Happening or non-happening of some event or a condition. That can be a condition precedent or condition subsequent. Next one, event referred to should be collateral to the contract. If it is a promise in the contract, if it is a part of the contract, it is not considered as contingent contract. Next one, contingent event must not be a mere will of the promisor. If it is a will of the promisor, is it considered as a valid contingent contract? No. Event must be uncertain. Nobody should have a control over it. If it is bound to happen, it is not considered as a contingent contract. Rules regarding enforcement, section number 32. If a contract is contingent upon the happening of an event happens, valid. Does not happen or becomes impossible to happen, void. If a contract is contingent upon the event non-happening, if the event happens, void. Does not happen or becomes impossible to happen, valid. If a contract is contingent upon the future activity of a person like fraud or something, if that conduct happens, valid. Does not happens, void. Then contingent upon event happen within a certain time. If the event happen within a certain time, valid. Does not happens, void. Non-happen within a certain time. If it does not happens, valid. Happens, void. Next one, agreement which is contingent upon the impossible event. Section number 36. If there is an agreement to do something which is contingent upon the impossible event, valid or void? Void, not enforceable by law. Example, to enclose a space by drawing two parallel lines. Is it possible? Not possible. Then section number 68 to 72, quasi-contract. Quasi-contracts are not contracts. They are not made by parties, but they are imposed by the law, and they are imposed by the law to provide the justice, and they are based on equity. It is based upon the Latin maxim called as, what is the Latin maxim? Nemo debet loculatari lex liena justa, means nobody can enrich themselves at the cost of other or others. That is called as what contract? Quasi-contract. Features, there is only a right for what damages? Liquidated damages. Means what? Reasonable amount. Does not arise from the agreement to the parties. It is imposed by the law, and it is a right in persona, means available against a specific person, not against the entire nation. Types, we have section number 68, necessaries supplied to the person incapable of what? Contract. Any necessaries supplied to the person who is incapable of contracting, or to the person whom he is legally bound to support. Based on this, they asked a question in the previous examination. Then the assets of that incapable person is liable to contribute for that. That is a justice required. For example, any supply of necessary items to a minor or unsound mind, they are not responsible. Their assets are responsible. Next one, section number 69, reimbursement of person paying the money due by another in the payment of which he is interested. Instead of landlord, tenant pays the property tax. Can the tenant recover it from the landowner? Yes, section number 69. Section number 70, obligation of the person enjoying a benefit of non-gratuitous act. If a person has received any services, other person did not have the intention of rendering that service at free of cost, then whoever has received the benefit of the services must pay for it. Section number 70. Section number 71, responsibility of finder of lost goods. The finder of lost goods is considered as what? Daily. he is supposed to return the goods back. Under section number 71, you cannot keep it quasi-contract because nobody can enrich themselves at the cost of other. Section number 71, money paid by mistake. Any money paid by mistake are under the coercion. Can the person keep it? No. If some money is transferred to your account by mistake, can you utilize it? No, it is not your money. Nobody can enrich themselves at the cost of other person. You must transfer it back. Quasi-contract. 5 contract, 68, necessary supplied, 69, payment by the interested other than the one who is legally bound to pay, 70, non-gratuitous act, 71, finder of lost goods, and 72, money paid by mistake are under coercions. So whatever discussed in this video is only a rapid revision of provisions of the section number 1 to 75 of Indian Contract Act 1872. We have discussed all these things in class in detail with the help of many examinations. So this video will help you guys to recall the provisions one day before the exams or 10 days before the examination without wasting much of your time. For special contracts, I have made separate videos and I've already uploaded them in the YouTube. You guys can go through it, which might help you guys in the preparations for examinations.